Put it there. The procedure which is required to be adopted by a tribunal adjudicating a claim for compensation for death or injuries in a railway accident is not required to have the standard of proof as beyond all reasonable doubt, and the same is required to be on the basis of preponderance of probability. The decision is to be on the touchstone of preponderance of probabilities, and unless the tribunal is convinced that the claim is not genuine, such claims are not liable to be rejected by taking a hyper-technical approach requiring establishment of a case beyond all reasonable doubt. This court has taken the essence of the law laid down by the Supreme Court, wherein it has been laid down that once the initial burden is discharged by the claimant that the deceased passenger was having a valid ticket, the onus is shifted from the railway administration to disprove the same. This court has seen that the issue number 3 regarding the entitlement of compensation has been decided against the applicant only because of the issue regarding bona fide passenger has been decided against the applicant. Since the findings of the first in the aspect of bona fide passenger appears to be decided erroneously, this court is of the opinion that the aspect of bona fide passenger has been properly proved, and accordingly, the issue number 3 regarding compensation would have to be decided for the applicant. In view of the aforesaid discussion, the instant appeal stands allowed, and the impugned judgment by so and so is set aside. Applicant is accordingly held to be entitled to a compensation of Rs 4 lakh as quantified by the scheme. Aforesaid amount will also carry interest at the rate of 9% from the date of filing of the application for the Learned Tribunal till the date of the payment. Appeal according to the
Okay.
yes. No.
Under item 55, there must be a restriction on the ground. There is
Review.
no feasibility.
Review.
Yeah, review it. So otherwise, my salary may not be given. So that's why. It may kindly be
Today,
taken.
we have to rise at 3 o'clock. There is some meeting at NGA.
That's
so
why at
just
1
after-
PM, Lord, may kindly take.
1 p.m. 1 p.m. have to rise.
Before 1 PM anytime.
No, we are sitting till 3 o'clock. 3 o'clock.
May not reach. Last 2 times also did not reach. That's why.
No, not before the motion. We'll have to complete the motion. After the motion, we'll try. Yes, Mr.
Doctor, item
Mr. Mahmood, what's the item? Item number?
55 supplementary.
Yes,
May I make a mention on listing, your lordship?
motion matter.
It is a contempt matter, your lordship. To come in, nowadays it comes in order.
New
Yes.
fresh matter.
Yes.
Have you filed, Mr. Sir?
Yes, it is filed. It came twice, but didn't reach.
May I please, Lordship, listed for admission on 11 September. I mean, matter is a very urgent. Last 14 years, we are not getting any salary.
It's a new writ petition.
Lordship,
It is a new writ petition.
no new petition. The case is 6 weeks after listed for. It is now 8 weeks over.
Next week, it will not be possible. There are only 2 working
The-
days. The week thereafter. The week starting
On
from
11.
11. Motion matter. Matter of which year? Why do you want to list it? Matter of which year? Why do you want an out of turn listing? Why do you want an out of turn listing? Why out of turn listing? What is the urgency?
Urgency my lord, we were newly in this particular petition. We were challenging my appointment. That's the reason that we have already heard about the patient. After that, matter
You
is
file your affidavit. You file your affidavit.
not-
Listed for what purpose?
no orders.
No, what purpose? Is some practical purpose is going to be served. File your affidavit. Make a mention. We'll have it for disposal. Okay. You have been implemented newly. Already implemented. File your affidavit. Then make a mention. Otherwise, you have to give time for filing affidavit. Yes.
I'll beg to mention an item for listing, madam. There's an IA of a contempt matter of 2019, whereby madam, this new incumbent was not implemented, but his personal appearance was directed. So we have pass and speaking order, and we filed an IA for dispensation of personal appearance. On 8th, my lord,
Personal appearance is on which date?
13th,
By which court?
my lord,
By which court?
court 5,
Won't it amount to a review?
my lord.
Won't it amount to a review of the order?
My lord, since we have passed this
No,
speaking order,
understood.
Yes.
I think you should do that. It should go before the same bench. Ultimately, you are seeking a review of the earlier order by which personal appearance was directed.
Yes, in spirit it is yes, my lord.
We don't mind taking up the matter, but propriety may not permit us. You may have good ground, which appears to be that you have complied,
Yes, sir.
and so that personal appearance thing has become mere academic. Isn't it? That is your stand.
My lord. Sir, I have been informed, my lord, that court 5 won't be sitting for a very specific period.
Okay, let us see. When do you want?
8,
Next week.
yes,
Let us try.
8, my lord. Leave glory.
Have you filed or not?
Yes, filed, my lord.
Yes. He is not well. 28. Your senior is BK Gogoi. It is submitted. That's the BK Gogoi Leonard. Irrigation department, have you informed? You have to inform for irrigation. Don't make a mention without informing. You may have very good and genuine reasons, but you have to inform the account. Mr. Upadhyay,
Lord.
free matter.
Lord.
It is submitted that BK Gogoi Leonard, counsel for the petitioner is unaware. Matter accordingly stands adjourned. Will be said after 1 week, 2 weeks, 28, 29, and 32 separate orders.
Obliged.
Just a- Yes, 1 9. Some difficulty. Some difficulty today. You are for whom? Your name is Esboirak. Okay. Have you informed the transport? Have you informed the transport department? You informed them will adjourn, but without information, without consent, no mention. Transport department, they have got a standing consent. Ask your senior colleagues here on the other side. Try to inform, come back again. Yes, next.
Sir, I am also same. I have not taken consent from the other.
Without consent, don't mention.
Engaged counsel is out of the station.
We'll adjourn, but without mentioning, not at this stage. Without informing. Inform them.
Obliged.
But in this matter, my lord, we have received a letter, man. Our letter has been responded by them. They are my cultural secretary, my lord. They have written to me, my lord, seeking 3 weeks time, because my lord, they have stated in this letter, as the matter is related to entitlement of gratuity or not, a comprehensive review examination is required on the appointment of the incumbent. Act rules, office memorandum related to the matter, etc., which will take some time. Therefore, kindly praise the honorable court for additional tips.
But making a request after 1 decade, is it proper? The matter is pending since 2013.
Yes, yes.
10 years have passed. Now you're making a request that you review the entire matter. Is it proper? And that too, we have heard this matter.
At least instead of 3 weeks, 2 weeks may be granted, but not last time. Let them.
No, Mr. Sutia, we are not against granting of time. We can grant the time. But we have already heard number one. And the issue is the straight cut issue. The application of the Gratuity Act, you cannot deny. It's only a matter of calculation and funds, arrangement of funds. Only on that aspect we have directed you to seek instructions from where you will gather the funds. Certain matter is difficult for us to adjourn.
So at least, my lord, 10 days, at least, my lord, let me have what they have said, my lord.
Last, but
La-
next time having this for finally. This matter was heard at some length on 29/8/2023, and after recording the tribal submission and the issue involved, comma, the T.C. Sutia, the learned additional senior corner at the firm, had prayed for some time as the question of arrangement of funds would arise. The Sutia, the learned state council, however, submit that the respondents would require some more time to take a final decision. Not fair. However, I'm not fair on, and accordingly, a prayer has been made for grant of an adjournment. However, considering that it's been pending for about a decade, comma, as a last opportunity, comma, and this time is granted to the state to have the instructions transmitted to its council. Sarah, this under the column, under the heading of the later on, we fix the date. For 12th of holiday.
16,
We'll have it on 14th of
14th of
14th,
September.
Lord.
14th.
12 I'll be out of.
Huh?
12 I'll be out of state.
14th.
14.
No, next week there are holidays we are granting
Yes.
some more.
Deeply obliged.
Let us see if you are here. Yes. Last Monday.
He was placed under suspension on account of his arrest. And after releasing from arrest, he did a subsequent investigation for the authorities have neither extended the order of suspension nor the department of filing this case was taken.
In the meantime, the period is over.
My lord,
When?
my lord, the suspension,
Yes.
Lordship, we have filed an affidavit. It has been served on him, but it has not come on record, I believe.
that's a equitable copy of the
What have you stated in the affidavit?
only they have stated that the criminal case is pending, so he cannot be released.
Have you got the judgment of the division bench?
My lord, I have that the cover judgment pursuit to the judge.
What is the name? Rekibuddin.
On referring the order of recruiting.
Where is Rekibuddin?
That judgment was that has put the cover. Criminal case in case of
Okay, yes. Law has settled that Ajay Chaudhary's principle would also be applicable in case of a deemed suspension in the reference made by the learned single judge. in the division bench in recurring case. So there no scope for you to take another step.
Otherwise, he has been paid according to the affidavit, your lordship. He has been paid all the subsistence allowance and all, and the case is sub judice. That's why.
It's not enough. Yes, they will dispose this of.
Recently on judgment has been passed to division bench. The last trial may be considered.
What has been said?
For the reasons stated herein above, we hold that there is no merit in this appeal. However, since Rule 61A of the 1964 permits the authorities to place an employee under suspension when disciplinary proceeding against him is contemplated or is pending, and considering the fact that disciplinary proceeding has in the meantime been initiated against respondent number 1 by serving memorandum of charges upon him, we make it clear that this order would not come in the way of the disciplinary authority from exercising jurisdiction under Rule 61 of 1964 rules and issue fresh order of suspension if so advised. No, no, it was recent. This is recent judgment. This is recent judgment. 22. Passed on 2/3/2023.
Will not advise you what to do. It's up to you. Will not advise you what to do. It's up to you. But will satisfied with the interfere with this order of proceeding.
This portion may be observed.
No, it is up to you. It's your liberty. Why should we advise you what to do, what not to do? We can examine the matter which is before us.
Sir.
But we'll give you one liberty that you can post him in any non-sensitive post. Third PM concerned counsel for the petitioner. Also heard the CS Salary Learned State Council and
When-
three as Dr. Learned Standing Council Revenue Department. Considering the issue involved and the fact that the state respondents have filed the affidavit in opposition on
Yes, sir.
Lordship, it may not be a. We have served the copy. Affidavit in opposition possibly has not been filed, your lordship. I just got the file right now. It's not in the process.
and
Of,
also respondents have filed the affidavit in opposition, by serving a copy to the learned counsel for petition. This matter is taken up for final disposal at the motion stage itself. Since the copy of the affidavit, since the affidavit is not tagged with the records, Hazarika has handed over a copy of the same to the court, which is made part of the record. Give a copy. The a short issue is involved, which involved in this present petition. The petitioner was serving as a lat mondal in the office of the circle officer, Jorhat West Revenue Circle in the West Revenue Circle, and was placed under suspension by an order dated 17/10/2020. The state suspension was made under Rule 6, 2 in as much as the petitioner was arrested on 15/10/2020 in connection with ACB PS case number 49 of 2020 under section 7 small a of the Prevention of Corruption. It is the case of the petitioner that though he was released on bail on 17/11/2022, till the time of filing of writ petition, neither any disciplinary proceeding nor any order for reviewing the suspension was passed. Sri Khan, the learned counsel for the petitioner, has however submitted that after filing of writ petition, he has been he has come to learn that a disciplinary proceeding has been initiated by issuance of a show cause notice on 25/7/2023. The learned counsel, however, submits that by such initiation, the requirement of the mandatory review cannot be obliterated. The learned counsel has also referred to the decision of a division bench of this court in the case of Rekubuddin Ahmed versus State of Assam, reported in 2020 to GLR 621. The Honorable Division Bench, in the said judgment, which was by means of a reference by the learned single judge, has held that the principles laid down by the Honorable Supreme Court in the case of Ajay Kumar Chaudhary versus Union of India, reported in 2015, 7 SCC 291, would also be applicable in a case of deemed suspension, wherein a government servant is put under suspension on because of the fact that he was arrested and was in custody for a period exceeding 48 hours in accordance with Rule 6, 2 of the state rule. The learned counsel for the petitioner has also faced before this court a decision dated 19/6/2020 of this court, passed in WP 3124/2020, whereby, following Haridas Sinha, whereby, following the ratio laid down in Rekubuddin, laid down in the case of Rekubuddin Ahmed, Supra, interference was made. Sri Hadarika, the learned state counsel, as well as Sri Dr. the learned standing counsel revenue, have, however, submitted that the charges against the petition are grave, for which he was also arrested in the connected police case, and therefore reinstatement cannot be in the interest of justice. After consideration of the rival submissions, this court is of the view that the point involved is no longer res integra in view of the categorical, in view of the ratio laid down by the Honorable Division Bench in the case of Rekubuddin, whereby it has been held that the requirement of a review of a suspension order cannot be done away with in case of has to be followed even in case of a deemed suspension. In the view of the matter, this court is of the unhesitant opinion that the present order of suspension is unsustainable in law, and according to the same is satisfied. However, considering the gravity of the allegation, which has been emphasized by the learned state council, it directs that while the suspension has been interfered with, requiring consequential reinstatement of the petition, the authorities could be at liberty to post him in any non-sensitive.
Also, just one point. This ACB PS case number so and so is pending. That may be observed, Your
We have
Lordship.
already said that.
Also, I'll hand over the.
Yes, please. And try to give a request. You take this back. It's a hunt. Yes. Yes.
What are the targets? Take third.
Hmm. Accredited engineers. We have taken up this matter, isn't it? You are on contractual basis. Now the period is not over.
My lord, he has not annexed his latest contractual engagement order.
When were you
We don't know. We
inducted
don't
in
know
the
yet.
services? Okay, we'll issue notice at this stage. Mr. Hendrik, we'll issue notice at this stage. Third, 3 SB Lustre, Current Counsel for the petitioner who has put to challenge an order dated 13/7/2023 issued by Panchayat and Rural Development Department, whereby his contractual engagement as accredited engineer of the Razatila GP under Katigora development block in the district of Kachar has been terminated. Full stop. The petitioner has alleged that the state order suffers from arbitrariness and no proper opportunity was granted to him. Full stop. That notice be issued, returnable by 6 weeks. Your B and D.
P handy.
P.
P for Pablo.
P and D learned. You are sending counsel.
My lord, on behalf of K Council.
P and D learned counsel appearing on instruction of Sri K Kumar. Learned sending counsel. PNRD accept notice on behalf of respondent numbers
1 to 4, my lord.
all the respondents. That extra copy of the petition served upon him. When next week starting there are holidays. Can you serve him today? Can you serve him today? Next 3 days are holidays. Extra copy is served upon him during the course of the day. Yes, next.
File. Otherwise, this is covered by attack. This document like to issue a notice. Basically, what we are saying is, my lord, even though it is contractual, because based on certain allegations, my lord, we have been terminated. Since my lord, allegations has been taken out of, therefore,
It's not a termination simplicity.
Lord, if you kindly come to page 37. Yes, it is.
But there is a contradictory judgment on the same issue wherein
Now we are issuing notice at this
issue
stage.
notice.
You take instructions, we'll consider your submission. Third, we can show the Learned Council assisted by Sri R.M. Deka for the petition Full stop. The petitioner is aggrieved by an order or an order dated 28/6/2020 28/6/2023, whereby his services as accountant cum computer operator has been terminated. Full stop. It is though the petitioner has submitted, though the petitioner has, though it is submitted that the appointment was contractually in nature, comma, determination is based on certain allegations, and therefore it is the contention that the petitioner ought to have been given a reasonable opportunity to defend his case, which has not been done. Full stop. That notice be issued, returnable by 6 weeks. Yes. Keep sending letters. All the respondents,
All the respondents.
What had happened in the European
can you
order?
serve him by today?
Well, in the European order, the name of the petitioner has been wrongly typed. Subsequently, after filing of the petition, they have come out with correction. You may be permitted to file an additional.
Since the senior counsel for the petitioner informs at this stage that a corrigendum has been issued with regard to the impugned order, as there was some discrepancy in the name. Full stop. The state fact may be brought on record by way of a petition. So, Bora, what is this?
Village commissioner appointment for this 19 the DLC rejected for date submission of application. At page 19 at seal number 2, I am just right column. Seal number 3 different on that. For the following case of Abhijit, what has happened?
When did you submit your application?
Actually, I submitted within 3 months of the date of death, but they had misplaced. Thereafter, when I approached,
Is this fact been acknowledged by them,
not,
or is it your allegation?
yes,
that it was
yes, yes, but in 2018 itself, where after the decision, I made a representation. Representation is page 21. So I stated the whole facts in my representation. In fact, the whole bunch have been lost. Lordship, in case of Abhijit Kolida, Lordship notice has already been issued. The entire bunch have been lost.
Okay. Madam, we issue notice. Take
Lordship,
action.
yes. However, Lordship, this is only a contention that the application was misplaced. And the first application that he submitted, it is not annexed also.
Now you have to dispute that on affidavit. If you say that it's the wrong date, this that. Third, 3. B.P. Bora, Senate Counsel for the petition, who is aggrieved by non-consideration of his case for appointment on compassionate ground. Full stop. In the case of the petition, that his father, Bolen Chandranath, was a forester, grade 1, in the office of the divisional forest officer, comma, forest resources survey division, comma, Guwahati, who had died in harness on 21/11/20. Though it is the case of the petition that he had applied for a consideration for appointment on compassionate ground on in time, comma, the application was misplaced, and thereafter the decision was taken not to consider the case of the petition on the ground that the application was filed beyond permissible limit. That notice is issued, returnable by 4 weeks, MS as You write Islam or Ahmed?
Ahmed,
Yes, Ahmed learned. You are sending counsel or PN counsel? Sending counsel.
PhD department. Oh, forest department, sorry.
That is sending counsel. Forest department. Accept notice. Accept notice on behalf of responsible 1, 3, 4, 1, 3, and 4.
5,
Three.
2, 5, and 6.
For 2,
5, and 6.
2, 5, and 6. That extra copy of the writ and serve the font. The learned counsel for respondents by today. Can you serve today?
Yes.
During the
Yes.
course of the day.
Obliged.
Yes. Sohan, arrest Sohan. What is the matter?
मतलब गांव बड़ा appointment मतलब गांव बड़ा
Non-appears for petitioner on call, whereas the state is represented, whereas the respondents are represented by three Secretary, the London State Council, as well as three as Dr. London Standing Council, Revenue Department. In the interest of justice, please Dr.
Lordship, I have received an instruction yesterday late evening, Lordship.
What was the that issue?
Yes,
Reversion. Yes. Now what?
Lordship, this has already been referred to the concerned department, Lordship, from the Office of the Chief Secretary. And they are contemplating, Lordship, dismissal of from service of the petitioner, Lordship. This is they have intimated. I have the copy.
See, we cannot prevent you from doing something which is not permissible, but that will be subject matter of a challenge where we may need to say something else.
Lordship.
To explore that option, that whether even if you are treated as a general candidate, you could have been accommodated in some posts which are below in the hierarchy. That was the consideration. Has that been? Have you explored that option?
Lordship,
done
that I
that
have not,
exercise?
because in the late evening, Lordship, I could not contact even after I received this instruction, Lordship.
I'm excited to inform you. This is not an instruction. This is what we have already known.
Lordship.
The APS have given the views. No, at this stage, what can we see? We cannot preempt them from doing something. It may not be legal. We are not commenting on the legality. No, we can say that he is not having instructions with regard to the directions contained in the order. Let them have the instruction. That will amount to reiteration of the order. Will come for motion.
Lordship.
Third, Sri M.K. Chaudhary, Learned Senior Counsel for the petitioner, assisted by Sri P. Bharadwaj, Learned Counsel. While this matter was considered on 25/8/2023, this court, after recording the facts involved in brief, had directed that till the next date, that is i.e. today, 1/9/2020, no final orders be passed, and the authorities were also directed to explore the option of having the services of the petitioner in any other post which he could have been otherwise entitled to as a general category candidate pursuant to the selection, pursuant to the recruitment process conducted in the year 1998-19. MS M. Bhattacharya, an additional senior advocate Assam, however, informed that part instructions have been received and praised for some more time to obtain the full instruction. Sir, how much time, madam?
Lordship may post it not next week, after that, Lordship.
You tell us a date,
Yes, Lord.
list for motion on
Lordship can mix it on 11th or Lord,
we'll have it on 13th,
11th,
13th,
30th, Lord.
on 13th of September 2023. We'll extend the interim.
Lord.
You're protected by it. Interim order passed at the extension till the next year of. You can serve, or if you want, you can issue notice at this stage. Madam, the instructions, yeah, full instructions, then let notice be issued. Returnable on 11th, 13th, returnable 13th. MS Bhattacharya,
I'm appearing for 1 and 2, Lordship.
the learned additional senior advocate Assam accepts notice on behalf of respondent 1 and 2, whereas
3 and 4.
the borderline understanding council corporation department accepts notice on behalf of respondents 3 and 4, and P. Sharma for APSC for PSC. That extra copy of the written served. Can you serve today? Serve it today because there are holidays. You have to get this instruction. We serve during the course of the day. Then it is important.
Deep stabilizer.
Item number 5 is very better. Item number 5.
The first order, if you are not here, we cannot wait for you.
Exactly.
Sorry. There is no urgency also.
Very simple.
Simple or complex, you are not bothered. If it urgent, we can give you an out of turn, otherwise not. You should be here. Cannot give you, cannot pray. Go back. Somebody should have made a prayer. We already accommodated.
Maybe taken up at 2 measures.
No, sorry. Is there an urgency?
Appointment is keeping bad.
Urgency is not there. You wait till your turn, maybe at the last of the motion. Not like this.
Just like
Last. Press. Should have somebody to make a prayer for adjournment. We'll grant. We always do that. Yes,
I told you one. Lord, the petition of the order passed by Sonam, what appointment of with the engineer Qatar. What happened? When there you also can see the page 109 is the appointment letter. We worked there for 1 week. After that, the head told the appointment letter some correction required to be done. The next issue went to think that the head said nothing to it, there is no correction, we are not giving you back. But then you don't come to the office from 22nd May. My Lord, the state is the obligation, the welfare of the person with max right to life. Now, this is the way state is functioning. Also, can you see the appointment letter at page 109? In view of the lordship got that.
First, your synopsis should not be 3 pages.
My Lord, it's too long, quite unnecessary.
If you have a synopsis of this kind, there is no requirement for petition.
Exactly. I do accept, even I had the feeling.
Now, what is your difficulty?
My Lord, your lordship, can you see page 109?
109.
In view of recommendation of the state level committee on compassionate appointment.
Now, that we have seen.
Now, after that, my Lord, the next letter your lordship can you see?
Where is the discontinuation?
My lord, they didn't say anything. My lord, it's a
Yes,
verbal-
madam.
We have to take instruction.
Here for PNRD,
No, water is.
water resource. Third, P. S. Dr. London Senior Counsel for the petitioner. Assisted by Siddhant Dutta.
Shubham.
Shubham Dutta. Fourth, the petitioner claims to have been appointed as a grade 4 within bracket Khalasi by an order dated 8/5/2026 on compassionate ground and pursuant to the said appointment order, she has joined her post in the office of where
Executive Engineer Qatar.
executive engineer Qatar. However, the grievance of the petitioner is that immediately thereafter, on 19/5/2026, the head clerk, on the pretext of making certain corrections, had taken back the appointment order and had asked her and has informed that her services are no longer required. It is submitted that till now there is no decision conveyed by any order regarding such discontinuation. Sir, that notice be issued. Have you written to the authorities?
My lord, it's right in.
You have to write. Your thing has been taken out. Did you approach your senior, the boss of the office?
My lord, it is at the biggest of the executive engineer.
No, your representation. These are the matters where you need to file representation. There is no order discontinuing it. If order was there, you come to the court. Somebody has asked you not to come. First, you do to write to the office, then write to the chief engineer, secretary. Let notice be issued, returnable by 6 MS. J. Gogoi, standing counsel.
3 and 5.
No. Who is for one? Commission Secretary Taxation.
Lordship,
Three.
one is wrongly imputed. Lordship,
Why taxation is party?
we are nowhere connected with it. So that maybe is correct.
And Commissioner Secretary Finance.
That may be necessary.
No, you cannot, nowadays you cannot just strike off. You file application.
Finance may be necessary. But
No, for one, you need to take
number one, we shall file it.
At this stage, Sri Doctor, submit that as for number one, that there is some error in describing response number one, and he pays for liberty to file necessary IA for correction. Finance, Sri P. Nayak, Leonard, Council, Finance Department, Standing Council, Finance Department, accept notice on behalf of response for 2, J. Gogoi for 3,
3 and 5.
3 and 5, and CS Hazarik, State Council for response number 4. Pendency shall not be a bar for representing, for submitting representation before the authority for redressal of our grievance.
And matter related to compassionate effort. Part of the site that on 2016, my lord, there the department has forwarded the application for compassionate effort on 18 May 2000.
Our GPay
My lord, DLC has recommended the statement.
Question.
2017 that my lord,
Learned counsel for the petitioner who is agreed by non-consideration of his case for appointment on compassionate ground. It is the case of the petitioner that his father, Hono Kanto Tae, who was working as a grade 4 employee under the establishment of the superintendent of handloom and textile, Jonai, in the district of Dhemaj, had died in harness on 15th April 2016. The petitioner, being eligible, had applied for appointment on compassionate ground, and it is claimed that the district level committee had also recommended the case of the petition in its meeting held on 29/4/2007. However, thereafter no consequent action has been taken for consideration of the case of the petition by the state level committee. That notice is returnable by 6 weeks. Textile department, madam, you,
I am for respondent 1, 2, and 4, handloom and textile.
what is your name?
A long-termer.
A.
Long-termer.
Longcomer. You are with whom?
Mr. Ardhar.
A. Longcomer, done it council appearing on instruction of the Ardhar, understanding council, handloom and textile, accept notice on behalf of respondents 1, 2, 4.
I am 3 and 4.
Whereas the TC should get under additional training on accept notice on behalf of respondents 5 and 5 and
3 and 5.
3 and 5, sorry. 3 and 5. पहला वाला 1, 2 and 1, 1, 2 and 3. Extra copies is served today. That extra copies are served on the Learning Council for respondents today.
tendency is no power for tendency is no power for
If the projection made by the petitioner that his case has not been placed before the SL is correct, pendency shall not be a bar for such placing of the case of the petition before the SL in its next meeting. That after recommendation of real these cases yes.
Sir,
Sir,
I'm
what is this?
appearing on behalf of respondent number 2, 4, and 5.
2 is the master.
Yes, sir.
Dig over. Who dig over? Exit over. Dig over. Arbora dig over. Who is dig over? Mr. Bhuya, your chambermate. Rituparna Bora. Arbora Rituparna Bora, is it your chambermate? Arbora is connected with you. Arbora. Dig over Arbora. Arbora is Rituparna Bora. And appears for the a prayer for adjournment has been made on behalf of the petition. Whereas your C. Sharma,
Yes, sir.
Senate Council, is present for the
2, 4, and 5, Lord.
for Senate Council Dimahasa.
Yes, sir.
Senate Council, NHTC is present along with the State Council. There are in the interest of the list of the week. It motion will come on.
Bless you.
Yes, Mr. Hawk.
The better part of the non-appointment of the non-completed government.
Recommended by DLC.
SLC has
Rejected.
Yes.
Why?
it is just cover under 5% quota.
So there was an earlier decision which said that go for clause 15 of the honorable court, go that to ask the SLC to go for clause 15, you'll say para 15. According to here, it is not apparent whether that clause 15 is there or not. So that's the thing which needs to be clarified.
As talk standard counsel for the petition, who is aggrieved by the rejection of the case of the petitioner for appointment on compassionate ground by the state level committee in its meeting held on 23/12/2019. The petitioner had earlier approached this court in wide WPC 6118 of 2019, which was disposed of by an order dated 11/4/2019, directing consideration by the SLC. However, it is submitted that the case of the petitioner has been rejected as on the ground that there were no vacancies within 5%. The learned counsel submits that from the impugned minute, it does not appear that any exercise was done to explore the option under paragraph 15 of the office memorandum dated 1st of June 2015. Para to notice returnable by 6 weeks. PWD. P. Nayak, London. Sending consecutive notice on behalf of 1, 4 and 5, whereas
I am for
PS
20.
other current state council access notice on behalf of Respondent. And extra copies of the petition upon the relevant council for respondents during the course of the day.
Tendency may not be bad.
Pendency for what?
If-
No, it has already been rejected. Right?
Fine.
That's a positive word.
Yes. Okay.
They fix the date. Cannot go back now. Somebody has taken that. Yes, next. Is there any urgency, Mr. Bora?
They are going to fill up some food.
What food?
They have called for the vacancy. There is the order passed by the honorable court.
Did. Next, sir. Next, sir.
Can it be on 8?
The candidate pertains to different process as a part. I
What are your grounds of carriage?
marks we have obtained in the 2 pages of so there are written examination and there is computer. So what they did my lord, they have made me qualified in the written examination and called me in the interview, my lord, the computer test, and ultimately my lord by order is 82 months. This is my lord for petition number
Yes.
1, my lord.
Yes.
They have given this result of the my lord examination saying that last portion
Not
result
qualified.
not qualified. I had talked I think 2 months back saying that give me my marks, but I marks obtained by the candidate in my case that last elected candidate in the official candidate how much they got, but they on the and there is a message under the law to publish the merit. They have to publish.
Now, if you are have not been responded under the RTI, you have the avenue for filing an appeal.
We are waiting for the results of that check in some connection.
You see, you have been separately communicated that you are not qualified. If you are challenging this, we are not saying that you are there is a bar for challenging, but you need to have specific ground. That such candidate is an inferior candidate, or the marks are obtained only because you have failed. You come to the court.
We have to take.
See,
We
Mr.
do not know if the people who are selected, my lord, if my lord, can you see the written results? I have just published, my lord, some written results are published. Not even the name of the candidate they have given, my lord.
See, you have been individually intimated regarding to your disqualification. That is even not required. That is even not required. They have done that, sending an individual communication that you are not disqualified.
Yes.
You are not qualified.
My lord.
After that, we don't think that there is something opaque or non-transparent. What else did you need? What are your grounds? Only because some information is not given, that becomes the ground of challenge. That has got a different avenue, different line of challenge.
Yes, my lord. So if I may go to the grounds, my lord, then by the truth contemplate that there is a mention publicly married.
We are not here to decide academic matters. What the rule says, what the rule doesn't say. If you make out a case that yes, some persons who are not meritorious as you have been appointed, you interfere. You participate in the selection process. Same rule. If you had been selected, you would not have come here to the court. Go back to the rule. You have to make out a specific case that yes, this person was not even there in the selection process. He has been appointed. Or that he doesn't belong to the OBC. He is treated as OBC. There is no such averment. Only because of the sake of challenging you come to the court, you cannot accept. See, these are appointment recruitment process which are concerning hundreds of students, hundreds of candidates. Now on 3 incidents without any specific allegation.
Cannot, because we have
That should not be
we
the
don't have any information pertaining to any candidate who has been selected.
you take avenues under the Act. RTI, it provides for appeal.
2 months I have
It
waited
provides
for-
for yes, you file an appeal if they have not given the information.
There's a provision for appeal, my lord, RTI.
No,
The appeal, second appeal.
they are not giving any reply.
No, even non-reply, you can still be aggrieved. Non-forensic reply is a ground for
By
being
state
aggrieved.
commission.
Difficulties, my lord, there is the responses are very, my lord, inadequate.
That is it. That is exactly we are trying to put across to you.
My lord,
That if you are aggrieved by non-information, by non-giving of information or giving of information which are not adequate, you can put the appellate authority. That is not what I thought for. Or this is not given. Difficult.
I don't think, my lord,
Third 3H Puragoha Internet Council for the petitioners. How many of you are there? Petitioners who are 3 numbers. The petitioners who have submitted to be belonging to the OBC category were aspirants in a recruitment process for filling up various grade 3 posts under the state, which was initiated by the advertisement dated 25/3/2022. It is submitted that there was lack of transparency in the recruitment process, and apart from mere communication that the petitioners were not qualified, the marks obtained by the petitioners vis-a-vis the marks obtained by the last appointed candidate in the OBC category have not been disclosed. Three, PC Chutia, the learned additional senior government advocate, Assam, however, submits that the petition discloses that certain information were sought for under the Right to Information Act, which has got inbuilt provisions for filing appeal, and without exhausting the state provision, this petition has been filed. Full stop. He further submits that in absence of specific allegations against any candidates who were not deserving, this petition is not liable to be entered into, as it is a settled principle of law that an unsuccessful candidate, after submitting to the jurisdiction of a recruitment process, cannot turn around and challenge the election only because of the fact that the state candidate was not correct. Therefore, contentions should be considered at an appropriate stage. That notice be issued, returnable by 6 weeks. The Education Department,
Actually,
One.
didn't represent the Board of Secondary Education.
No, no, procedural only.
Secondary Education Department.
Secondary. No, I can accept 2, 3, and 4.
Secondary Education Department.
Secondary Education Department, how it's made.
What? How is the Chief Secretary representing? What is the
Number
kind of
1,
heading?
secretary.
No, if you are reading, see how you have described it. Response number 1.
1.
State of Assam, representative Chief Secretary of Government of Assam, Secondary Education Department. So, remove this. Not strike off, modify. The TC should be additional clinical advocate. Accept notice on behalf of the respondent number 1,
2,
2,
3,
3,
and 4.
all the respondents.
4 is Malad Seba. I can accept it.
I think you have another counsel with you.
Yeah, DK Roy.
We'll record his
Yes, yes,
statement.
DK Roy, Malad.
Accept notice on behalf of respondent number 1, 2, and 3. Whereas DK Roy, is he present in the court today?
Yes, today.
Whereas DK Roy, understanding counsel. Seba, accept notice on behalf of respondent number 4. That extra copies of the description reserved upon the learned counsel for the during the course of the petitioner is at liberty to file I for correction of description of the number 1. What is this?
Okay.
This case, my lord, earlier, my lord, my lord, petitioner was
As per
subsequently, my lord, sent one letter issued, my lord, by Executive Engineer Guwahati Mechanical Division, my lord, Water Resources Department, S29. Compliance with Department of Government of Assam regarding disposal of ground appointment assessment. S29.
your
My
You-
name is Chairman from Mananek.
Yes.
And Biman Mit.
Yes.
Here it is. These are the matter of 7 process are pending before the for their appointment, my lord. So, my lord, application recommended by the DSC but cancelled by the SLC. So, my lord, my prayer is that, my lord, my lord, application may be considered, my lord, by the
SLC has given certain reasons for rejection.
but
What are the reasons?
that, my lord, I have not earlier application
Or-
recommended by DSC but
Three.
cancelled by SLC.
H. The learned counsel for the petition, who is aggrieved by non-consideration of his case for appointment on compassionate grounds. So, it is the case of the petition that his father Bhubaneswar Medhi
Lordship, may I? I'm very sorry, Your Lord. Lordship, it does not indicate that application recommended by DLC were cancelled. That is only for this Bhavani Tabuni, some other person, Your Lord. Lordship will see here. These are all dash, small signs in page number 30.
30.
30, Your Lord.
Yes.
For instance, your lordship, number 1, Ridip Kumar Das, your lordship will see there's a small dash in the 8 remarks column.
Yes.
Then in Bhavani Tamuli, there is this application recommended by DLC but cancelled by SLC. Then there are small dash, and for Biman Medhi also. There's no indication that it has been cancelled by the SLC, and in fact, your lordship will turn to page number 21.
Yeah.
It has been some RTA has been replied to him, and he has been in fact rejected by DLC on 2 occasions. Your lordship.
That annex matter, that is a subsequent effect matter. Letter issued on 26. Those are the which are cases are pending. It was issued on 26/7/20.
No, he is saying that because of this remark, it is applicable to this, but actually it has been done rejected on 2
Mr.
occasions.
Das, where is your consideration by the DL? Press consideration. which you-
That I have not,
Then how do you say?
because in view of this letter, my lord, recently. Earlier, I thought that, my lord, so I stopped the matter in the year 2015
See,
itself.
this is not a letter
Yes.
which has referred to any minutes of meeting of the SLC, number
Yes,
1. This is neither a communication from the SLC
Yes.
to you. Now you have inferred something from a communication, which may not be correct. Okay, who was working as what? Father
Yes,
was
sir.
working as?
My father was working as my lord, was UDA,
Who was working as the UDA under the Goalpara Mechanical Subdivision,
water resource department.
within bracket, water department, had died in harness on 11/4/2011. Put up. The dictionary content that he has received a letter dated 26/7/2020, from which it can be inferred that his matter was recommended by the DL. Whereafter, there is no action taken by SL. On the other hand, T.S. Hazarika, the letter state council, has submitted that the annexure to the aforesaid letter dated 26/7/2020 does not disclose any such recommendation by the DL. And on the other hand, it appears from the record that the candidature of the petitioner was earlier rejected by the DLC. Be that is commanded notice issued, returnable by 3. Everywhere,
It will be reference number 1 would be
Respondent number 1, Health
health and
Department.
family welfare. What is going on?
Yes, Lord. Health Department.
Every
main
case,
party.
some other department.
Yes.
Third time today, your lordship, some other.
Um, reasonable. It appears that there is the description of the respondent number 1 has been erroneously made, as the Department of Health and Family Welfare is not connected with the procedure. 3. SLC is 3. CS Hazarika, Learned State Council accept notice on behalf of respondent number 2
And 3, your lord.
and
What is
and even 3 is I think
4 is
3. Why Kamrup?
Yes, as it was considered by initially in the district wise, subsequently it is division. So the letter also is good. I have asked the client my lord, that completed people executive engineer for mechanical.
Okay. For 1, 2 and not 1, 2, 3 and 2, 3 and 4 also. 2
4, no, your lordship, water resources.
water resource. You have water resource.
No,
Water resource. Somebody was there. Madam J. Gogoi. Name should or not?
No, your lordship, name is not shown.
SC water resource.
No, not.
Ms. Pending council. Voted to accept notice on behalf of resident of court. Learned council free ask for the petitioner is at liberty, praise for a liberty to file I for correction of name is number 1. Court of liberty is granted. Cause this to reflect name of the standing council of your city council. And the name of SC Health and Safety Welfare Department. Yes, Mr. Ahmed, what is this?
In this case, my lord, Terminary had my lord Panchayat authority. Panchayat authorities, my lord, particularly the my lord, the Cow Panchayat in connivance with the my lord Anchalik Panchayat, without initiating any tender process in the financial year 2017-18.
Why is it come before us? We are bench 3.
Yes.
We don't mind taking a tender matter, but we are bench 3. Bench 4 matter. This appears to be a matter of civil bench 4, which is connected with the tender process. Registered to verify and list before the approval. Why so many number of KVS?
Actually, it's
How many KVS?
these are all muscular workers. So these caveats are filed accordingly.
They have not been made parties.
No, in this expedition, they are not made parties. You have come.
You are one of the caveators.
No, I am for the yes, one of the caveats.
You have been made a party or not?
Yes, I am the party. The NIT is the main party.
You are also caveator.
Yes.
And the beneficiaries.
Because on the last occasion, what had happened, the caveat, the reason for filing the caveat, the Union of India was made it a party, and the NIT authorities, although was made it a party, but I was not served with the copy. So this because of some apprehension on the part of the NIT authorities.
No, the other caveators are by beneficiaries.
It's same authority.
Beneficiaries.
Same authority, Lord. NIT has filed all the caveats.
Okay, apprehending that some other may
Yes,
come
yes,
to the
some
court.
other persons may come. But here in this case, only 7 persons have come.
What is your case?
May I please attend? My lord, the petitioners are now working as a high skilled master worker, and they have been paid 30 days, and their service they have rendered from the date of their initial engagement till date it is almost 30 years.
Yes.
My lord, they have approached before this honorable court, my lord, with the prayer for regularization of their services. My lord, I am dropping my lordship on the one part of the order of the learned single judge, my lord. My lord, I please to find.
You had come up to this court earlier also.
Earlier also.
Thereafter, what has happened?
My lord, yes, my lord, the relevant part of the state order passed by the learned single judge, my lord, I please to find at page 41.
Yes.
Page 41, the last paragraph, my lord. Therefore, in view of the above position, no direction can be issued at this stage to the authority of NIT to regularize the services of the petitioner. However, taking into consideration the length of their services, as some of them continuously in service since 1982, it is directed that whenever the ratio of 1:1.5 between the faculty and non-faculty members is petitioner's case shall be considered taking their respective length of service into consideration. The authority shall also consider the case of the petitioner belonging to the SCSP while filling up the backlog vacancy person communication dated past June of 2006. With the above direction, this writ petition is disposed. Now, my lord, as the regularization order has not been passed, therefore it has been carried into a read appeal. Now, my lord, the division bench, my lord, may be pleased to find the division bench order starts at page 45. Honorable division bench order, my lord, is at page 45, and the relevant paragraph I am relying, my lord, is at page 46.
Yes.
Having regard to the above fact, the appellant have already served for more than 30 years and they are still continuing in service. It will be in the interest of justice that the issue is considered again by the National Institute of Technology as well as by the Ministry of Human Resources, Government of
possible within 6 months from the date of receipt of the certified copy of the order. Pending decision on the issue, the appellants may be allowed to continue in service. If the appellants are aggrieved by the decision which may be taken, they will be at liberty to take their remedies in accordance with law. The appeal is disposed of. My lord, the direction was to reconsider the issue of regularization, my lord.
Until then,
My lord, accordingly, the NIT authorities, my lord may be pleased to find the NIT authorities at page 52 annexure 7, my lord.
Yes.
My lord, page 52 annexure 7, and notice has been circulated on 27/09/13, by which, my lord, it has been decided that a meeting will be held today on so and so at 4:30 p.m. in the director's office to discuss the MR daily wage workers to the president and secretary and on other members from the MR union. So, my lord, accordingly, the meeting was also held and a detailed resolution has been adopted at page 53. My lord, the resolution number 3, I am relying on this relevant. It is also resolved at page 53. My lord. Next page. Yes, sir. Resolution number 3, it is also resolved that the existing MR of the daily wage workers working in NIT sector since last several years are to be regularized from amongst the MR of the daily wage workers case-wise, subject to the availability and sanction of posts by the Ministry of Human Resource Development. It is also resolved that the MR of the daily wage workers who have got no requisite qualification and age in the regularization matter at present shall be given proper training and to fulfill the requisite qualification and age bar for the regularization matter, and management shall give preference. Resolution number 5, it is also resolved that,
yes,
my lord, so
Therefore,
as per norm. Now, my lord, as this has been resolved on, my lord, meeting dated, my lord, on 27/9/2013, the matter rests here, my lord. Then at page 54 annexure 8 is a, my lord, pay enhancement ordered for the petitioner, my lord, is also relevant, because, my lord, we are working at this moment as a high skill master to worker for which, my lord, our wages has been enhanced, but no regularization order has been came to be passed. Accordingly, my lord, the same process was going on, and suddenly, my lord, at page 57 annexure 9, an advertisement has been notified by the National Institute of Technology, my lord, dated 7/7/2023. Now, my lord, by virtue of this advertisement, the post has also been notified, my lord, wherein we could have been regularized. My lord, may be pleased to find those posts at page 60. Page 60, senior assistant, my lord, the senior technician, as well as, my lord, junior assistant at page 61. Now, my lord, our case is that as the, my lord, decision has already been taken by the, my lord, NIT authorities by of a resolution, my lord, as per the order passed by the Honorable Division Bench of the Honorable Court. Till date, my lord, they have not taken up or finalized the issue of regularization. And on the other hand, they are proposing to fill up these vacancies where we could have been regularized or adjusted. So therefore, my lord, without regularizing us, if these posts are going to be filled up by new incumbent, my lord, then our rights, my lord, can be affected. That's why, my lord, this advertisement is under challenge. And my lord, may to notice, my lord, and till then, my lord, if I can satisfy my lord, then, my lord, this post cannot be filled up, my lord, where we could have regularized.
how many of you are there?
My lord, at this petition, 10 petitioners are there.
Otherwise,
My lord,
how many numbers of similarly situated
17 highly skilled people are there, 10 people are
17,
my lord, 17.
17.
My lord.
And how many posts have been
My lord, the
notified
number of posts,
in your
This is the page
category?
number 9. 57.
In your category?
yes, page 57, my lord. Serial number 9, my lord, senior technician, direct, senior assistant, my lord, 8 numbers, junior assistant, my lord, is 15 numbers. 15 plus 8 is equal to 23, my lord.
You are working as MR in what capacity?
Lord, we are working in the capacity of, my lord, my lord, page number 26, my lord, may kindly have a look, my lord.
Here in the
My lord.
advertisement breakup, you could be adjusted against serial number 9, senior assistant.
My lord. My lord.
Number of vacancies 8, and the other one?
Other one is junior assistant, number of vacancies 15.
Yes, Mr.
Okay, here in this case, the petitioner has also made a mention in paragraph number 8 that the age relaxation is also there with regard to the petitioner. So they can very well participate in the process. There is no bar with regard to that.
No, that's a different submission.
Yes, Lord.
You have a division bench judgment which has said that you consider. You by considering you can reject their case until such consideration allow them to continue.
So they have not been restrained from continuing with the service. Lord.
No. Have you
Yes.
considered?
That aspect of the matter, I have to obtain the instruction. But the other aspect is that, Lordship, they have not been restrained from continuing with the service. And they have been given the additional benefit to participate in the selection process also.
Chaudhary, that's not the answer.
Yes.
Division bench has said that you consider until such consideration allow them to continue.
Yes.
You consider them, you reject them. Matter ends there. But without abiding by without complying with the direction, if you open a fresh recruitment process, they may participate. That's a different matter.
Exactly.
But that consideration part yet to be done. It might have been done. Take the instruction. You have not got the instructions regarding the order of the division bench, honorable division bench on.
Order of the division bench, they have communicated, but they have not received any instruction from the higher authority. That means the MHRD.
They have to take consideration.
Yes. So this is
and for consideration doesn't mean that you have to appoint them.
Yes.
If you whatever you do, you have to give reasons, which can be matters of judicial review. That's a different matter. But if you fill up all the posts,
then Lordship may fix the matter in the next week. I will obtain the instruction. Short date may be.
Don't go ahead with the filling up of this at least post.
No, this particular thing is not going to happen within a short period of time.
No, if you go ahead, third party rights will be.
It's not the instruction that I'm having. This is not going to happen within a short period of time. So next date may be given on the reopening day because the 4 days are.
When is the this thing in the selection? They call the date fixed. Last date.
Date is not fixed. It is not fixed. No fixation. So Lordship may take up the matter on 7th. 3, 4, 5, 6.
$60?
64 is a reminder.
The last date for submission of application to online was for date last, but they may 16/8 may not have message enclosure by 16/8/17 online. So now we have 16/8
So nothing will happen within 7 days, Lordship. That's why I'm telling Lordship this matter will be taken up on 7th. By that period, since for the 3 days, this holiday is there. So by 7th, this matter will be taken up. I will obtain the instruction with regard to that. The pursuant to the judgment of this novel division bench, what has happened.
Third, 3-year we have learned counsel for the petitioners. The petitioners who are 10 in numbers are working on master rule basis in the where NIT sector. In the NIT sector. Full stop. The petitioners claim to be highly skilled MR who have rendered about 30 years of service and was seeking regularization. Full stop. Though initially the petitioner had approached this court with a claim for regularization, this court by judgment dated 17/1/2008 passed in WP 719 of 2007 had held that such direction for regularization cannot be passed. However, some observation was made regarding certain eventuality under which the cases of the petitioner to be considered. There are, be that as it may, in the writ appeal preferred by the state petitioners against the aforesaid judgment by WA 369 of 2008, the Honorable Division Bench had passed an order dated 5/12/2012 by directing our fresh consideration by the authorities, namely the NIT sector as well as the Ministry of Human Resources, Government of India, for and till such time, the petitioners were to be allowed to continue in service. It is the categorical case of the petitioners that they are continuing, and in the meantime, their remuneration have also been enhanced. Also, the grievance of the petitioner is, however, with regard to a recruitment process initiated by an advertisement dated 7/7/2023, which includes posts wherein the petitioners could be considered for regularization. Also, it is submitted that the said recruitment, so far as it pertains, the post in question is in the teeth of the order of the Honorable Division Bench mentioned above. As till now, there is no consideration of the case of the SP Chaudhary, Learned Standing Council, and I has submitted that there is no bar for the petition to take part in the recruitment process, and it is also a fact that the petitioners are being taken care from time to time, and their remuneration were all enhanced. He accordingly pays for some time to obtain the instruction. So it appears that the petitioners are being allowed to continue, and even their wages have been enhanced. That will not do away with the requirement, do away with the direction of the Honorable Division Bench requiring consideration, requiring a reconsideration of the cases of the petition for their regularization, which does not appear to have been done. In view of the above, though time is granted to the Learned Standing Council as per his request to obtain instruction, it is directed that no steps be taken to fill up the post of junior and senior assistant, which are part of advertisement at 7/7/2025, without first considering the case of the petitioners for their regularization in terms of the earlier direction of the
Lordship may fixing the matter on 7th.
as agreed to by the parties. This one
7th.
Para, set an extra copy of the
By today, sir, Lord.
we served upon Speaker to enable him to obtain this. We can dispose of the caveat.
Yes.
Caveat.
I will obtain all the necessary instructions.
Caveat.
Caveat discharge, Lord.
SP Chaudhary, counsel for NIT filter, who has lost this caveat with regard to a recruitment process initiated by advertisement dated 7/7/2023. Of the caveat will be heard in the event this court proposes to pass any interdiction. Caveat stands heard, separate or not.
Knowledge.
7.
We are basically paying for equal pay for equal work. That is your document, like you said.
The work is what?
ANM, my lord.
Contractual.
Somebody is getting more pay.
Matlab, we are working for the last 20 years, same job we are doing, my lord. Our counterpart regulars are getting everything, we are not.
You are working in the same establishment.
Yes,
Counterpart means
the regular, the one who is regularly,
you are in a contractual
we
basis,
are contract.
but work is the same.
But that too pursuant to an advertisement.
Part 3K and further done senior counsel for the petitioner assisted by Sri RM Das, RM Teka, done the counsel. The petitioners are aggrieved by are seeking parity in pay with regard to work, with regard to the duties for, with regard to the services rendered by them as ANM put up. It is submitted that do the petitioners are working in the aforesaid capacity on contractual basis, the said induction in the service where by a duly conducted recruitment process, and therefore there cannot be any discrepancy with regard to the same services vis-a-vis the regularly vis-a-vis the incumbents who have been appointed on regular basis. At this stage, Commander returnable by 6
1 and 2 I am appearing.
B. Gogo Internet Sending Council Health and Family Welfare Department accepts notice of their respondents to finance field and enact 3 extra. Today, within 6 weeks, make switches by a week. Enough.
Working under the official method, and he has worked for more than 10 years. The APC respondent method. There was a different notice method take 18 for filling up a post of field assistant Sahayak and Gardena Madi method. So they participated, he along with some other candidates participated, and their name initially manner is in the provisional merit. It is page 50 manner by number last
Yes.
but the final merit says their name was not incorporated. So being agreed manner, they approved court manner. So she has got page 50 manner. Provisional merit of the so when manner name were not incorporated the final merit this manner, they approached this court for regularization of their service manner.
You are agreed by the speaking order.
Yes, manner.
We will examine that. Part 3 M.A. Chaudhary, Senate Counsel for the petition, who is aggrieved by a order dated 10/1/2020, whereby the claim of the petition for regularization
And regulation of this manner minimum test.
Suitable economic package.
for claim of the petitioner for to afford him suitable economic package has been rejected. Full stop. The Senate Council has submitted that there were earlier rounds of litigation and the impugn speaking order is an outcome, is an offshoot of the earlier directive of this. That notice be issued, returnable by 6 Borua A. Borua, Senate Council APDCL, accept notice on behalf of all the respondents.
Yes, my lord.
That extra copy. Okay, or by 1 week, within a week,
By next week we will start.
within a week.
Your fact certificate, yes.
Third, the MAI Senate Council for the petition who is aggrieved by the action of the respondent authorities in not allowing him to join and serve pursuant to his appointment after selection as a constable within bracket QB in the Assam. Full stop. It appears that the petitioner was arrested on 18/10/2022 in connection with CIDPS case number 5 of 2020, which seems to which IDPS the petitioner was arrested, which appears to be the reason for such action. That notice of motion is returnable by 6 weeks. We CC20 as the current petition notice on behalf of responsible.
All the respondents. All the respondents.
That extra copies to serve him in a week. Please allow me the PPC
4851.
41.
4851 2023.
Okay.
4851. Give extra copies. Yes, next. What is this?
Development is there, man. I may be allowed to go with liberty. Man.
What was the issue involved?
So actually, I challenge the seniority list, my lord.
How?
Of that, my lord, from the grade is the junior engineer, my sub-junior engineer.
To the post of?
For the post of my lord,
Junior engineer.
next promotion post is JE, my
Okay.
junior engineer.
Third, K. Das Planet counsel for the petition, who is aggrieved by a gradation list of the post of sub-engineer grade 1 civil in the education department, wherein the petitioner is serving. The learned counsel, however, submits that there are certain developments for which he would like to withdraw this petition with liberty to file fresh if so advised. Also, our Upadhyay, learned planning council, education department, who does not object to the state prayer put compare petition according to dismissed on required with liberty. Yes. Okay. I don't. Somebody is not able to pass through. It is submitted that free as Buraki. You have been exonerated. You have been exonerated. We will record your name, doesn't matter. We'll have this in practice. Your name? HP Nepal. Learned counsel appearing on inspection. And had HP Nepal, learned counsel appearing on inspection of free as Buraki, who could not appear as he is unwed. Also heard, madam,
Why Kunyak on behalf of MD Bora?
give your name. Konyak. MS Konyak, learned counsel appearing on inspection of MSMT Bora, the learned standing counsel. Transport department. Full stop. MS Konyak, the counsel for the department has placed for this court a copy of an order dated 25/8/2023, from which it appears that the petitioner has been exonerated of the charges which were leveled against him in connection with departmental proceedings in question. Such exoneration is, however, without prejudice to the CIDPS case number. This court is of the opinion that in view of such order dated 25/8/2020 of department, there is no live cause of action, and according to the is closed. What is the matter?
Lordship, he is claiming for promotion and he has already retired from service.
He's retired in 2021.
As Chaudhary was there. There was delay in coming to the court, number one.
Yes, your lord.
You have not stated the criteria for such promotion, and you have retired on 31/3/2021. Okay, at 2 o'clock. Right. Yes. Yes. Where is the second proposed notice?
39.
39. Let us read this. Yes. Now, don't you think that is in the intermediate stage? You have come to the court. The DP was when were you arrested? 371. And DP was initiated when? You have already disclosed your defense, madam. This is only to file representation against the finding of the inquiry officer. The question of the prejudice will not come here. Understood. Your defense is already disclosed in the written statement of defense. Now, how do you say this? How do you challenge this without there being a final order? You convince the DA, disciplinary authority, to take a view. When have you come, madam? This was when? Did you come immediately at the starting of the DP? You participated in the DP, you disclosed your defense. Why are DP stopped? First, there is no law that this cannot go parallelly. It can. Number one. Number two, you have to make out a case of prejudice that if I may disclose my defense in the DP, I will be prejudiced in the criminal case. You have already disclosed your defense. You should not have submitted. You could have come to the court. I'm not required to submit my reply. My criminal case will be prejudiced. Your defense is disclosed. No, sorry. Not a case. Not a case for notice even. Not a case for notice even. We are dismissing this. No, premature. 99 is a stale case, madam. There are recent cases, but those cases will be applied only when you can show prejudice. You have already disclosed your defense.
I'm denied all the allegations.
Not this case, the stage of coming. You have to satisfy today. No, not now. You have to satisfy. First, you tell us what prejudice, what are the grounds for which we need to interfere, number one, with this. We are not going into the effect. You show the law that after disclosing your defense in the written statement of defense and after the inquiry is over, you are given an opportunity to fight your second show cause, you come before the court challenging the state. Is it the state? At this stage, why should you go by the inquiry report? You have the right, the opportunity to convince the DA that this inquiry report is incorrect. Don't go by it. You convince. What is the meaning of a second show cause notice, madam? What is the meaning? What is the meaning? Meaning is to convince the disciplinary authority to take a view which is in your favor by ignoring the views of the inquiry report. You are not denied with that chance. There are no grounds, madam. At this stage, you cannot come.
The office of which the affair was heard and the charges are named, then it is better to drop the picture.
Have you come at that stage? Did you come to the court at that stage that disciplinary procedure has been initiated? I will be prejudiced. That is the reply. This is only against the inquiry report, officer's report. Sorry. I tell you, we'll give reasons.
In my reply, I have clearly stated
Third, MS Third Chaudhary, Learned Counsel. Learned Counsel for the petitioner who has approached this court against in connection with the disciplinary proceeding. It is the submission that the DP was started after the petitioner was arrested in connection with Bongaigaon PS case number 305 of 2022 under section 384/511 IPC. The petitioner is working as an UBC of the Bongaigaon DEF. This court has, however, noticed that the present challenge is only with regard to the second show cause notice dated 17/8/2023. And in the meantime, not only the petitioner has filed the written statement of defense, but has also participated in the inquiry and is presently given the opportunity to file his reply to the finding of the inquiry officer so as to convince the disciplinary authority not to accept the same. In the opinion of this court, the present petition is misconceived apart from the premature. So, MS Chaudhary Learned Counsel has submitted that there are decisions that a disciplinary proceeding is liable to be dropped if there is a criminal case. So, the state the state principal would have applied if the petitioner would have come at the initiation of the proceeding. But in this case, it is not in dispute that the petitioner has already disclosed his defense by filing written statement against the show cause notice at this stage, I may show that the Senate Council prays for some more time to obtain instructions. List for motion 7.
My
Yes.
lord, I have to pay my lord. Item 19, Lordship may kindly record my name. Lordship already disposed of the matter.
We have recorded your name as on your instruction or junior receptive,
My lord,
not more than that.
deep development.
Doubtful family, my lord, having experience and my lord, both are able to
Item number
effect in the selection process. My lord, but very surprisingly, my lord, on 11/3/2023, the selection selected on another
selection
private person, my lord,
for
my lord,
for the post of
Taura, my
Nampura.
lord. The selection body, my lord, selected the private person, my lord. Accordingly, my lord, challenging the state selection list, my lord, earlier approached the honorable court, my lord. And honorable court by order dated 22 5/23, my lord, dispose of the registered direct final in 1 week. My lord, therefore, my lord, because of his illness, my lord, he could not file it within that time. So, my lord, we filed
Did you
it
come before this court for extension?
my lord, only some time we given file.
You did not come before this court for extension. That this is the reason for which I could not file the appeal within the time prescribed by this court to grant me extension. We could have granted. Now, where is the fault of the appellate authority? The rules prescribed for a particular time. He has to go by the rule.
I am reading it.
He can withdraw and file an extension in the previous shift petition, your lord.
You can file a mistake. I think that suggestion is best. You file a miscase.
That is the dispose of that is why I have not.
Miscase, not IA. File a miscase. In a disposal of matter, it's permissible. There is a case of Indian Airlines, Ansari for Indian Airlines. You can file. That this is the what has happened. I could not file it in 6 period. You take instruction. Okay. Third, the Brahman Senate Council for the petition whose demand is with regard to a recruitment process for the post of Gaonpura of the Gaon Pradhan in lot number 6 of Telia Chapodi Isamat under Katawal Musa in the Nagaon. It is submitted that the state cause of action was espoused in an earlier writ petition, WP 1581 of 2023, which, however, was disposed of by this court on 22/5/2023, granting liberty to the petition to prefer an appeal under Rule 1(c) of the Executive Instructions before Jurisdictional Divisional Commission. Full stop. This court had granted a week's time for such filing. It's the case of the petition that due to his illness, he could not prefer appeal within the time stipulated, and when the appeal was ultimately filed, the same has been rejected as being time-barred. That CS Hazarika, the London State Council, however, submit that in spite of that instead of filing a new writ petition, the ideal course would have been to seek an extension of time in the earlier writ petition by filing an appropriate Review of concerted counsel for the praise for granted a week time to obtain trust.
Lordship, in this case, he has not, the DC has, the division commissioner has refused to take according to his allegation, not the rejected. It was not rejected, the appeal.
That refusal
Going to
to
file
take,
it, but they have not taken
yes,
it.
tampered.
Tampered.
Yes, so Portolo, advertisement for
Radiographer.
radiographer. In which department? GMC.
Department of Health Department.
GMC. Where? The health department.
Yes,
Thereafter,
By the director of health. Service. Thereafter, your lordship
your results have been withheld.
no, Lordship.
has not been, initially it was, but later on it's been declared that I was not selected on the ground that I was not completed the course from a recognized. Now, your lordship, I have completed the course from Assam down the
Did you complete the course on the last date of submission of your?
yes, prior to that. The lordship may
Yes,
find-
Mr. Upaman.
Lordship, here, Lordship, he was provisionally, Lordship, selected by Annexure 5, Lordship, page 25, Lordship, wherein at page 26, Lordship, next
Yes,
page,
yes.
her roll number was there, Lordship, in the
Thereafter-
fourth row.
thereafter-
But Lordship, the petitioner herein is challenging her own provisional select list, Lordship. Lordship may have a look at the prayer, Lordship. She wants to set aside and quash the selection list. If the
He wants a substantive appointment. He wants a substantive appointment, not provisional
But
appointment.
Lordship, what my instruction is that she has not obtained the degree from as a regular student.
How do you, as a regular student?
Yes, Lordship. It was just a skill, like something like Lordship provisional 6 months course or 9 months course. Lordship,
What is the requirement, Mr.
Remember,
Butler?
your lordship may kindly-
17.
Yes,
What is the requirement under the
your
advertisement?
lordship kindly come, second last column, videographer. Page
Yeah.
7.
certificate course or above. Lordship.
Radiographer, correct?
HSSLC pass, videographer technician certificate course or above from any government organization.
Yes.
Now the certificate.
You have the certificate code.
Yes.
There is no need whether he has done it on a regular basis or.
Then in that case, Lordship, she has filed a representation on 21/8/2023, Lordship. The department can take the call, Lordship.
It comes for this court, not third 3G border learned comes for the petition who is aggrieved by her non-consideration for appointment as radiographer in a recruitment process initiated by an advertisement dated 7/12/2021 issued by the Health Department, Directorate of Health Services.
Assam.
It is the case of the petitioner that one of the qualifications stated in the advertisement was to have a radiographer technician certificate course or above from any government recognized institute of Assam, and the petitioner has such a certificate from the Assam Downtown University, and therefore fulfills all the requirements. The petitioner is aggrieved that in spite of this command, she has not been offered the appointment in spite of her provisional selection. That notice be issued returnable by 6 weeks.
Yes, sir.
That is pending council health and family welfare department. Therefore,
All the response.
all the that extra copy within 1.
All right.
Yes, what is this, Mr. Rao?
Pattern, became the appointed to the constable in the year 2011. Thereafter, the respondent authority, they directed him to undergo nursing training in a hospital. He went for training. He came back for training, successfully completing the training, and he joined Milord at Unique Hospital, Borhampur, as a nursing constable. He worked there for 7 years, and thereafter he was sent on deputation to Central Police Hospital, Dergaon, as a nursing constable in the month of October 2022. So in the month of February 2022, precisely 22nd of February 2022, a trainee in the unit, he fell sick and he was admitted to the unit hospital. So the trainee's name was, she was from Nagaon, the petitioner, he, knowing that he is from the same village, he asked, since he was sick, he will be in need of some hot water. He asked that sick trainee.
No, we are not too much interested in the fact. What has happened thereafter? DP has started. DP started.
There were some allegations of sexual harassment and rape by the attendant of the training. Pursuant to that, an FIR was lodged, and I was arrested, and I was in judicial custody. While I was in judicial custody, in jail, the commandant, he became over enthusiastic, and within my judicial custody, he gave the first show cause notice. Then I came out. I told the commandant, I'm in judicial custody, I cannot file a reply. I came out, I represented before the commandant that since the criminal case is pending,
Where?
and that
Where?
yes, that representation I'm just telling. Page 67. I asked him that kindly do not proceed with the departmental proceeding since the criminal proceeding is pending. Then, my lord, I was of the bona fide belief that they have stayed the proceeding.
Well, let us.
But they
Where is the so-called notice?
Page 49.
page first so cause notice, my lord will find page 49.
Yes.
First so cause notice 8/5/2023. I was released on bail on 29/5/2023. Doctor will kindly see the charge. May I read it? Page 49.
Thereafter, what has happened? Inquiry.
What happened?
Inquiry was conducted.
Yes,
Yes.
inquiry conducted.
Milord, what they did, Milord, I submitted representation. I was of the bona fide belief that they will not proceed with the inquiry. Milord, behind my back, he was the commandant. Milord, he appointed the inquiry officer, proceeded with the inquiry, and he gave me the second so cause notice, saying that he will be removed from service, and he enclosed the inquiry report along with the second so cause notice. That your lordship will find page 68. Page 68 is the second show cause notice. He said that he has come to the conclusion that I'll be removed.
Where is your advocate's notice?
Sorry.
Where is your advocate's letter that
67.
67? What's the date?
Date is my lord 17/8/2023.
But you have already submitted your reply to the so-called notice.
Yes, my lord. Lord, what happened? I'm telling you. When I was inside jail, I came out. They exerted tremendous pressure on me, saying that you submit your reply or we'll go ex parte, my lord. He submitted his reply. He only said that categorically denied the charges, and the actual truth he said. But the fact is that, my lord, how can you hold an inquiry behind my back and the inquiry officer, my lord, held all the charges to be proved? And what are the charges? Sexual harassment and rape. Because the inquiry officer proved rape in a departmental inquiry. And So far as sexual
It is not a question of proving rape. It's the allegation. Allegations cannot be there. It's a criminal case. That's a different matter. Inquiry officer will not put you to death penalty.
No, that's
Will he put on the death penalty for rape?
Lord, Doctor will kindly appreciate one thing because the allegations in the chokos, first chokos notice, and the FIR is a replica of the FIR, allegations in the first chokos.
You have chosen to file your reply.
No, reply was submitted in a situation.
Where have you stated?
My lord, I stated in my paragraph that
Where have
reply
you
was
stated?
submitted.
No, where have you stated that it was under pressure?
No, that was possible. Kindly see.
No, where have you stated, Mr. Das?
Yes, yes.
You have shown your reply by the advocate.
Para 9, I have stated.
Paragraph 9.
Yes,
Page,
that the petitioner back to submit that while he was served with the chokos notice that is so and so, he was still in judicial custody. Situated thus, he was neither in a position to inspect any document nor was in a position to furnish a proper reply to the state chokos notice. As such, the petitioner intimated writing to the respondent. Number 3, that won't be possible on his part to reply to the chokos notice until he is out on bail. The petitioner could not retain a copy of the same written intimation in view of his detention in jail in judicial
we
custody.
do not think that you have been, you have disclosed, you have done a candid disclosure. Your page 69 is something else which you are submitting.
Page 69. Page 69 is the inquiry report.
Yes, inquiry report.
Doctor,
Come to
kindly
the.
go through the inquiry report.
We are not going to the inquiry report. Kindly see what the inquiry officer has stated in the second allegation, second paragraph.
Second paragraph.
Second paragraph, 7th line. Accordingly, first chokos notice was issued on so and so. Reply was received on 3/6/2023. You have not said anything about this.
Then my lord will
If you are not having a candid disclosure, we are not going to have you any relief in a report.
Kindly go through the inquiry report for a moment. There was not.
Why should we go to the inquiry report? Are we the primary authority? Are we the disciplinary authority?
No, my lord.
Why at this stage?
Why I am saying so, my lord? The disciplinary authority, my lord, gave the check. My lord, what is the requirement?
You cannot take your chance to blow hot and cold.
No. How can they, my lord, after my representation, when I gave you representation, kindly do not proceed. Since criminal case is pending, how can they conduct the inquiry behind my back? Number 1, my lord. Lordship will, if Lordship will kindly see the inquiry report, not a single statement of mine has been shown. Lordship will kindly see inquiry page 70 onward. Statement of PW1, PW2, PW3, PW4, PW5, PW6, PW7, PW8, 9, 10, 11, 12, 13. My statement is nowhere below. I never participated in the inquiry mill. I never participated in the inquiry mill.
See the first line.
They have written that, but Lordship will kindly.
Why should we disbelieve?
Lordship referring to my lord.
Page 70.
70.
Yes.
Yes, my lord.
She examined all relevant witnesses acquainted with the fact, along with the victim so-and-so and delinquent nursing constable Bablu Bhia.
Yes.
What else do you need?
This is the statement of PW1
Yes.
in the regular inquiry, departmental inquiry,
Yes.
my lord. I never participated in the departmental inquiry. It was absolutely behind my back, my lord. Lordship will kindly see PW1. He is a listed witness. Then PW2. Where is the deposition of the, my lord, delinquent employee? Lordship will see. Lordship will kindly scroll down the pages of the inquiry report. Lordship will see where is my statement, my lord.
I'm not satisfied.
Lordship will see.
At this stage, we are not satisfied.
Lord, my statement is nowhere.
Nothing to be agreed. You will have put grounds in your, if any order is passed for penalty.
Why am for your lordship at this stage?
And with these kinds of allegations, you are coming to a court of equity. Sorry.
Serious allegation,
Sir, sorry.
My lord, allegation is serious, my lord. I am not going into the allegations, my lord. Allegations are there, my lord. Lordship will kindly appreciate the procedure they have followed, my lord.
At this stage, we are not appreciating the procedure.
Where is the mandate?
This case has not come. You have submitted to the jurisdiction of the inquiry officer. You have not made a single statement in the affidavit that you are under duress to submit such a reply. You have submitted reply. It has been considered. Inquiry is done. Inquiry may be bad. You convince the disciplinary authority that inquiry is not good. It has been done by violation of procedure. Why should we enter into the
Milord,
step into the shoes of a preliminary
I understand, Milord. Milord,
authority.
same
No, not at this
position,
stage.
I have also in my mind.
Our roles, the disciplinary, as in a disciplinary proceeding, are very limited.
Milord,
Third-
same position I have in my mind. Only one thing, Milord.
Sorry,
What they are going to do is that, Milord, they are by virtue of the
we'll give you liberty to challenge the appropriate stage, not at this stage.
Milord, kindly appreciate, Milord. I never, Milord, I haven't disclosed my defense, Milord. Milord, with all due respect, because the recent
You have not even stated. Are you candid to the court? Have you been fair to the court? Enquiry officer says that you have replied. You have not even stated that you have replied.
Milord, I
You
have
are
stated-
you are showing a reply by your advocate, taking time. Where is your written statement of defense?
No, that, Milord, that, it is there, Milord.
Where?
I have annexed, Milord.
Where have you stated?
I have annexed, Milord.
You said that you had given by under duress. You have stated nothing.
Lordship will kindly come to
Sorry.
page
Part three,
41.
sorry.
Lordship will kindly see.
Sorry. Not a fit case. First page status.
I have annexed my statement of defense.
Maybe you find it out. This is not the stage of intervention.
Lordship,
First page
they
status.
are going to remove me from
Let
service.
them. You challenge it.
Lord, I have a loan of house loan of 15 lakh.
You may have 15 crores. We are not bothered.
How this
We'll
person
go into
will
the
survive,
particular
Milord?
facts of the case.
How this person will survive if they
Oh
remove
my
me?
God.
Lord,
Are we here to look after your survival?
What I am saying is that,
An accused in a rape case.
Lord, I am only an accused, Milord.
We are not saying anything on that in
I am
that aspect.
only an accused, Milord.
Yeah,
Only
that is
thing
why we are restraining from saying anything. Part
Milord,
three,
apparently
HK Das, Senate Counsel for
violence,
the
Milord,
petitioner,
by going behind my back, Milord.
who has put to challenge a second show was noticed dated 24/8/2023 pertaining to a disciplinary proceeding which was initiated by a show was noticed. Full stop. The petitioner, who was initially appointed as a constable arm branch in the year 2011, had undergone nursing training and was thereafter deputed to the Central Police Hospital, Dergaon, Kolaghat, full stop. While serving in the state capacity, an FIR was lodged on 26/2/2023 on the allegations of sexual harassment and rape, leading to registration of Dergaon PS case number 43 of 2023. Full stop. The petitioner was arrested in the state case and was accordingly placed under suspension. Full stop. It is the case of the petitioner that while he was in judicial custody, a show cause notice was issued on 8/5/2023 on similar allegations of sexual harassment and rape. Full stop. The petitioner has alleged procedural infirmity while issuing the show cause notice. Full stop. It is submitted that he had expressed his inability to furnish any replies. Full stop. However, on his release, the petitioner has submitted his written statement of defense by denying the charges. Full stop. Thereafter, a representation dated 17/8/2023 was issued through the council requesting for keeping in abeyance the departmental proceeding during dependency of the criminal case. Full stop. The allegation of the petitioner is that the inquiry was, however, conducted behind his back, and thereafter the second show cause notice dated 24/8/2023 was issued. Full stop. Thus, the Learned Council has accordingly submitted that due interference be made by this court of para. Three, T.C. Chutia, the learned counsel, the learned additional senior government advocate Assam, has however submitted that the allegations are very serious in nature, which include allegations of sexual harassment and rape. Full stop. He further submits that the petitioner, having submitted to the jurisdiction of the disciplinary authority by submitting his so-called reply, whereafter the inquiry has been conducted, comma, at this stage it will be premature for any interference. Full stop. This court is also of the view that unless a prejudicial order is passed by the disciplinary authority in the proceeding, comma, at this stage, comma, it may not be prudent to make any interference. Full stop. However, comma, an allegation has been made that the allegations in the disciplinary proceeding is identical with those contained in those involved with the criminal case. Full stop. Therefore, comma, by keeping the maintainability of the writ petition open, comma, that notice be issued, returnable by 6 weeks. 3. H.E. Chutia done it, additional senior government takes notice on behalf of all the respondents. Full stop. It is further observed that any action of the actions taken pursuant to the impugned second so-called notice dated 24/8/2023 would be subject to the outcome of this. You come up with instructions. We have serious doubt.
Response number 3 and 4 is not proper party, my lord.
Right?
The only commandant, what commandant I don't know. That is not sure.
APBN.
3. Commandant.
APBN district Nagaon.
Yes.
9
There is
APBN.
gap.
9
Gap.
APBN.
Gap.
Doesn't matter.
Gap.
It's somewhere serving to office.
I have an
But-
extreme prayer, but kindly consider.
We have said any action taken at the authority.
It is yes.
We have doubt in your maintainability. That, and come bring the records, bring the instructions. We want to see the materials on which the inquiry officer has proceeded. The procedural part only. We are not interested in the fact whether notice was given to him and whether he participated in the inquiry, and if not, whether it was on his own volition. If he has chosen not to participate, we are not going to be.
Yes, sir. He declined to, did not participate. Applies to.
Five. No. We'll take it up at 2 o'clock.
In this matter, our names have not been reflected in item 5.
Item 5. Yeah.
Mr. Chauhan, we had told that we'll take it at the end of the motion. It doesn't come. 5. List on non-appears for the petitioner on call. This court has been apprised that the names of
SCGAD.
SCGAD has also not been reflected in the cause. In the interest of justice, list on 8. Non-appears on call on the behalf on non-appears for the petitioner, even when this matter was called up on the 2nd of it. Motion put. Your time. Let's go to
49, my lord.
this matter, my lord, the petitioner has already retired.
That
And
we
on
know.
many occasions, it was a dismissal. And he takes time and goes away. Today, even he has not appeared.
Today you be there at 2 o'clock.
My lord, all right.
That is the criteria from sector 1 to
If you cannot establish your case or support your case by stating the criteria for promotion, where is the basis? Where is for forest department?
but when put to the purpose, won't put the- one of the
Mr. Gogoi,
This case,
finally is here in the
yes,
court.
my lord, petitioner has
Mr.
retired.
Chaudhary, allegation has been made that you are not seen in the court whenever this matter is listed.
Petitioner has retired, and the person against whom this prayer is met, he has also retired.
is there.
There was a prima facie view of the court
He
that
got the
things are
promotion
settled.
only after litigation. So only he got the promotion, two promotion in the year 2017. After the order passed by the Senate.
Third, Sri S. Chaudhary learned counsel for the petition, whereas the forest department is represented by Sri D. Gogoi, the standing counsel. Anyone else, Mr. Chaudhary, you are also there.
Yes,
Ini,
for PTC,
The PTC is represented by Sri B. Chaudhary,
3, 4, and 5.
the learned standing counsel. Good. The petitioner has approached this court with regard to the issue of his promotion. Full stop. The petitioner who was serving as a forester 1 has claimed that he ought to have been considered and promoted to the next higher post of deputy ranger, inasmuch as the private respondent number 6, who has been stated to be junior to him, was promoted on 17/1/2020. Full stop. It is submitted that even the promotion of the petitioner to the present post of forester 1 was done. And it is submitted that though the petitioner was initially appointed as forest guard, after a long 35 years of service, he was promoted to forester 2 and thereafter to forester 1. Full stop. The petitioner accordingly prays for a direction for consideration of his case for promotion. Full stop. Per contra, Sri D. Gogoi, the learned standing counsel forest department, has submitted that it is an admitted case that the petitioner had retired from the service as forester 1 on 31/3/2021. He has also referred to the earlier order of this court dated 28/8/2023, wherein it has been recorded regarding the inordinate delay in approaching the court and also the absence of any pleading with regard to the criteria for promotion, and therefore, full stop, and therefore, full stop. He accordingly contends that only by citing the instance of the response number 6 by claiming that the petitioner is senior to him, comma, that may not be the sole basis for which this writ petition can be entertained. Full stop. The each Chaudhary, the learned standing council petition, has also taken a similar step like that of Sri Gogoi. Full stop. Para. This court has noticed that on the last occasion, that is 28/8/2023, after recording the aforesaid submission, comma, Sri Chaudhary, the learned counsel for the petitioner, was granted time to obtain instruction. Sri Chaudhary, the learned counsel, however, submits that no instruction could be given to him with regard to the criteria of promotion. The standing council has also submitted that not only the petitioner has retired in the meantime, comma, even the respondent number 6 has also retired, and therefore there is no live further action to be adjudicated. This court, in exercise of powers under Article 226 of the Constitution of India, is a court of equity, wherein the conduct of the parties are of paramount importance. The petitioner had retired more than 2 years back and has filed this writ petition claiming retrospective promotion by citing an example of response number 6 by claiming that he is junior to the state response number 4. However, comma, even the criteria for promotion to the post of Forester 1 has not been stated in the writ petition. Under those facts and circumstances, it is also not in dispute that both the petitioner and the respondent number 6 have retired from service. In view of the above, comma, this court is of the opinion that no effective relief is entitled to. No effective relief can be granted in this case, even if a case granted in this petition in view of the above. The petition has proved. All right.
This case, petitioner was a appointed subject teacher in 50 subjects in the school of Kongo Higher Secondary.
That we know. Why have you filed this review?
Our petition was dismissed on some ground there saying that if you could look at page number 58.
I wait.
Yes.
Yes.
30. Page number 30. Both the petition accordingly stand made. However, considering the petitioner Professor Kumar Nath to have served for a long period of time, the case the authority has to observe that the subject of history is required to formally permitted in the school. The case of the petitioner may be considered in accordance with law.
Yes.
After that, came to know that the petitioner got the orders of feasibility report with him. The annexed in page number 59 and 60. annexures and deed. But, it is been hard and the subjects are history, my lord.
Have you been given the benefit of provincialization?
Yes,
You have been given already.
I was given that after that an imperial order was passed to which my post my appointment was cancelled on the ground that I had no feasibility report at that time with me. But now that we have the feasibility report, our only fear is that we could kindly review and modify the.
No, we have given already protected you that if you have since you have served for a length of time.
Only,
Now, now this is of 16, this feasibility report. Till 2023, you have not been given the appointment.
no, my lord, we have, but the order of the order where the order was given much later, my lord. The High Court order was given much later, so if the order could be modified, my lord, it would be much help.
What is your name?
Yes, sir.
Afridi. See, while we have dismissed the writ petition, we have given you some protection. Now you say that there was a feasibility report of the year 2016, correct? Now we have decided the writ petition the year 2023. From 16 to 23, what has happened to the feasibility report? No, we are not on that. We are not on that. We are not finding fault with you. It may be a communication gap, but from 16 to 23, no steps have been taken for your provincialization. For your then
There was no nothing done.
yes, Mr. Upadhyay, so for whom?
As in
Council.
council, yes, we have issued in 16 and 19. That is right. But the writ petition is 15, your lordship. And they are challenging the order of 14.
They could have withdrawn the writ petition.
At that time, we had no knowledge about it. After
Withdrawn and say that this feasibility report has come. Direction may be given for consideration in terms of feasibility report. Yes, department, anyone?
Secondary department
Secondary department.
is coming.
Mr. Chutia? Mr. Chutia? Secondary department. We need somebody from the secondary department.
Our role is very limited, your lordship. We have issued in 16 and 19. It is correct.
But in the 16 order, when you have mentioned this Banmukh HS school, have you verified that it
Yes.
contains the history subject?
Yes, after verification, we have given it.
No. Have you verified the document which has been annexed to the review petition? Have you talked with your client?
Yes. They have stated that these two we have issued. That much. Other role, we have no any other role.
You should have withdrawn the writ petition. You are not in touch with the clients or what? Anyone from secondary education? Now how will this, what review are you seeking?
Just that would like to get those order on record.
You have already protected you. In case the authorities are of the view that the subject of is required to be properly permitted in the school, which has already been done, the case of the petition may be considered. Then where is your apprehension? Your claim has been dismissed because at that time there was no feasibility report. And this court was also never apprised that there was some feasibility report in the meantime. But still we have said that if it is possible your case to be considered because you are working for a long period of time. I think I have granted you the protection. We'll clarify this part. We'll clarify this part.
Yes.
Madam, secondary education. Have you been served with a copy of this review?
Lordship, today we have missed a case, Lordship.
As of ready. As heard as of ready learned count for the applicant who has filed this application for review of the clarification of the order dated 2/8/2023 passed by this court in WPC 260 of 2015. Also heard the Upadhyay. Also heard
D. Musahari.
the Musahari,
D. Musahari.
the Standing Council,
Standing Council for
Secondary Education Department, as well as the Upadhyay, the learned Standing Council, Assam Higher Secondary Education Council. The issue in the writ petition instituted by the present applicant was the cancellation of provincialization of the services of the petition. Full stop. It was the case of the petitioner that he was appointed as subject teacher in history in the year 1997 at the Banmukh Higher Secondary School in the district of Sivasagar. It, however, appears that such provincialization was made along with the services of other teachers in absence of any feasibility report so far as the subject of history is concerned. Full stop. This court, after hearing the parties while dismissing the writ petition by holding that no case for interference was made out, that however made an observation that since the petitioner was serving for a long period of time, comma, in case the authorities are of the opinion that the subject of history is required to be formally permitted in the school, comma, the case of the petitioner may be considered in accordance with law. Para for any reference, comma, paragraph 30 of the judgment dated 2/8/2020 is expected below. The learned counsel for the applicant, however, submits that after dismissal of the writ petition, comma, but this was with your client. Why did your information, your source of your the time when you are being informed is not important. Uh, uh, comma, the uh, certain communication which are relevant to the issue were furnished to them by the client. By the first communication dated 12/9/2016 issued by the Assam Higher Secondary Education Council, comma, the feasibility report. No. Uh, provisional permission, a provisional academic permission was granted to the aforesaid school even for the subject of history. Full stop. A subsequent communication was issued by the Council CIL dated 26 to 2019, granting provisional academic permission to the state school in respect of the state subject of history. The Learned Council for the applicant accordingly submit that the aforesaid development could not be apprised, could not be under submit that this court could not be apprised about the aforesaid development due to ignorance of the petition. Full stop. He further submits that the state development may be incorporated in the order so that the consideration of the petition, so that the direction for consideration of the case of the petition can be done by taking into consideration the aforesaid two communications, which are of immense relevance. Three, further, the Learned Standing Council of the Assam Higher Secondary Education Council submit that the two documents which has been thought to which have been thought to be introduced in this review petition are not disputed. Para, in view of the aforesaid facts and circumstances from the order dated passed by the court in W stands modified by directing consideration of the case of the petition by taking into account the aforesaid two communications dated 12/9/2016 and 26/2009 issued by Assam Higher Secondary Education Board. The present application accordingly says. You should have placed this before 2016 document. We took the petition for hearing only in 2023. If you go very technically, these were not new discoveries. It was within the knowledge of your client, and client's knowledge means your knowledge. So till then, correct.
As part of set up allied and healthcare council Europe. And after forming that council, the names of the persons who have been practicing already, their name has to be enrolled in the register. That has not been done as far. So I have come up with my certificate. I have enacted the offer this certificate and gazette on
have they filed the
once they filed, it was
no, the court had ordered
Yes,
directed
it
to
was
file it
not
press.
subsequently
Lordship, subsequently I have received some instruction, Lordship, and Lordship, I am about to receive instruction from the Director of Medical Education, Lordship.
See, on the earlier occasion,
Yes.
this court has not accepted your plea. In fact, the updated 9/11/2020 The court has made an observation that your chair taken that the read is not maintained, not acceptable.
Yes, sir.
And thereafter you are direct filed additional effort.
Yes, sir.
Press effort. Let them file then.
Lordship, can it be on Lordship 13th of September, Lordship? By
This was
then-
on, yes, you are correct. It was on 11/20/22.
Yes, Lordship. But
Almost 1 year. Yes, what are you doing?
Lordship, I'm just praying for one last chance, Lordship. Can it be on 13th of September, Lordship?
Okay, we are on last chance, but on the day we'll go ahead with the
Yes, Lordship.
Heard MS we are senior counsel for the petitioner who submits that this court by the order dated 9/11/2020 had rejected and had held the plea taken by the department raising a question on the maintainability of the detention to be unacceptable, and accordingly a press affidavit was directed to be filed. Full stop. Though this matter was thereafter listed on a number of occasions, it is submitted that till date no such affidavit has been filed, and therefore, the case matter may be taken up for final. The Upamani, the learned training council, Health and Family Welfare Department, however, submits that part instructions have been received and he is about his and some more instructions are in the offering. Considering the aforesaid facts, circumstances, and also the interest of justice, a last opportunity is granted to the department to file press affidavit in terms of the order dated 9/11/2020. Is this case
In that, please, 20 plot.
Why did the bill file it up?
on 29/2020, by which time the affidavit is required to be filed.
Highly okay.
Yes. Naupura. Affidavits have been exchanged. Yes,
So far, he has filed one additional affidavit, Your Lordship. By the
for whom?
I am for the private respondent number 8.
And for the department, revenue department, and state. State has filed affidavit.
And he has filed an additional affidavit. From that affidavit, Your Lordship, from that affidavit, it is apparent that he approached before the divisional commissioner about filing an appeal, and that has been dropped. That has dismissed. Yeah, by that pursuit, he ought to have challenged this order, Your Lordship, instead of this repetition. That clear order is there.
Has? But that has been stayed.
And I submitted that interim order before the national government. This to register it as an appeal, and that was not my notice matter. And subsequently, my lord, on 22nd, 2020.
Have you stated this on affidavit? Have you stated this fact on affidavit?
Yes.
The additional affidavit.
Yes, I have filed.
Okay.
My
And thereafter has dismissed your appeal.
no, this is the close. They said, my lord, finally page 130.
But the interim order passed by this court, is it still pending? Is it
Yes,
still holding
it is
this
still-
bill?
Page 135.
You can hear this matter. If readings are over, instead of going to that controversy, whether it was an appeal in terms of the act, regulation,
yes,
or was it a forwarding of the interim order without even going to suspect, we can decide the subject matter.
Close.
No, that is okay. We'll decide your retention on merit. You file your affidavit. State. Tell us the date. Sir,
Matter may be fixed.
Tell us the date of your conviction. Matter of which year? 2022. There is a stay order. We fix it. Third free S.K. Roy, Senate Counsel for the petition, who has submitted that an additional affidavit has been filed. The state affidavit has been filed to explain the position regarding the allegation made that an appeal was preferred by the petitioner, which was dropped. The Royal Learned Council has clarified that at no point of time any appeal was preferred, and it was only forwarding of the copy of the interim order passed by this court, which was addressed to the divisional commission. And the said forwarding letter appears to have been treated as an appeal and was taken up expertly and subsequently dropped. Since the issue is before this court, and the rival parties have exchanged their pleadings, the writ can be listed for admission here. When?
September 12th also. Second 12th of
12 September.
yes, my lord.
We'll have it on 19th of September. 19th September. Tuesday.
Obliged.
So, Sarma, what is this? Forest? Yes, ma'am. Affidavit file.
No, Lordship, we are waiting instruction for this lot. Here the issue is that we are written to department. Department given an instruction regarding some other case, Lordship, which is annexed.
That is something internal
Yes,
to
sir,
it. We have to get the instruction.
Yes, sir, Lordship. The last time
Matter
we
is
gave-
pending since 2022.
I don't want to submit anything without the written instruction, Lordship. That's it.
We are proposed that council representing the forest department submit that instruction are yet to receive. On the other hand, Sharma, the learned counsel for petitioner has submitted that the matter is pending for more than a year. Considering the above, and in the interest of justice, allows a final opportunity of 3 weeks to file the affidavit. Please stop the state. Sarah, interim order passed today. To continue to the next zero. What kind of interim order? Okay. Okay, that is not in your interest. Come up with this structure.
Yes, sir, Lord. Yes,
Either this way or that way.
yes, sir.
Poster, fill up.
Obliged, Lord.
Right, I think it's fine. Regarding the promotion.
The D. Bora, Senate Counsel for the petitioner, established that there are certain additional facts which are required to be brought on record, and he prays for a liberty to file an affidavit would also have to be as the senior counsel
For LIC.
for the LIC who does not object in principle. Full stop, Sarah. List after 2 weeks. List after 3 weeks. To enable filing of an additional.
Obliged.
Yes, madam.
Yes, Lordship. In this case, we have received instruction, Lordship. Within 2 weeks, Lordship.
Which department?
It's PW, Lordship.
Public Works. Third record. Done it wrong for petition. Who submits that affidavit is yet to be filed by the respondent. Three, Nayak, P. Nayak, any constituted, however, submit that instruction have been received and he will be filing the affidavit in a top six. Doctor, please, doctor, 2 weeks
Lord.
to enable filing of such a. Tell us the date. We'll have it on 20th of September. Enough time, more than 2 weeks. 22.
Yes, my lord, here my lord, name was forwarded by Department of Pion. But DLC or changed the name as a non-redundant post by the boatman. That is why no like that's not how they Pion came converted.
Yes, but
Okay, instructions, they have reiterated the same things which have been mentioned in the SLC minutes, Your Lordship. It was given in the SLC minutes that page number 42, Your Lordship.
yes,
Same thing, Your Lordship, boatman, but it was given as since it's a redundant post, he was considered for grade 4, but there is no he has left for 2 years.
Was the recommendation of the DLC for peon or boatman? DLC?
DLC boatman, my lord. But department has sent his name is Pion. Grade 4.
Your father had worked with the IWP.
Yes, he was the handyman that died for the 15,
Handyman where?
pick up the road, permanent roller handyman.
DLC says boatman, but then SLC wanted to.
Boatman, let us see.
Page 28, my highly annexed from the department.
28.
Yes, from the two step page 28.
Yes, 28.
Then statement by the page 29. Suppose they have clarified that they are
Peon.
Pion. And then his name is sorted out is 29, 39.
Yes,
The one not does.
yes.
So
Now-
accordingly, against the Pion post, his name was gone to DLC.
Then where is the consideration?
33, Your Lordship.
35 minus space 35. It's DLC.
30,
Jagannath,
30, 33,
yes, 33.
serial number 9, Your Lordship.
9. Now they change it, how it changed from 4 to Pion.
You have a post of boatman.
So it is now redundant. That's what
No,
the issue. DLC gave us boatman, but then in the SLC there is a comment that boatman peon on executive engineer's request as boatman is a redundant post. So he was considered in the grade 4, but the main ground of rejection is that this has
But,
a gap of 2 years.
Will that be fair? Even if assuming he had applied for boatman, if that post was not there, your duty was to consider him for any equivalent. Now you consider him for a post which is not applied, a post which is not there, and thereafter you reject as being redundant.
No. It has not been rejected for redundancy, Your Lord.
Then
Page number 42, Your Lordship. Serial number 28, Your Lord.
Yes.
Application of the applicant was pending for recommendation for more than 2 years. Therefore, application spent is 4. Boatman is a redundant post, but on EE's request, petitioner's case was considered for grade 4 post.
it was grade
So
4.
some sort of correction was done. The main reason was this, the earlier one, Your Lord, the 2 years have elapsed.
The boatman issue has become, it's not relevant now, since your consideration was indeed made for any grade 4 post.
That fact also, that 2 years facts also not correct. I think so, but 2015, I don't know why they.
You filed your affidavit.
No, Your Lordship. We have just an instruction from SLC that the same reiterating the same grounds, Your Lordship. Just nothing.
What do you do? It is for final disposal.
Let me try to get instruction and file an affidavit on behalf of both DLC and SLC.
No, if your instructions are in sync with the the recordings which have been made at page 42,
Lord.
did not file any affidavit.
That your lordship just may have a glance, just a small instruction.
No, what is the how is the issue of 2 years been dealt with by the government? This
by
is not the this is not the first case or solitary case where for 2 years it has not considered reason. This is the subject matter of challenges many other repetitions. How is it been dealt with?
To go through, like, because
Mr.
he's
Burwa,
saying,
there are many cases of this nature.
Yes.
What is the line the court is taking?
My humble submission is that my lord,
No, not your submission. What is the law which has been? What is the interpretation given by the court? How are those cases disposed of?
within 2 years, my lord, Bochut Ranjan Das case, vacancy was not there. They spent its life, but here in this case, within 1 year, vacancy statement of that.
But,
so
there is a clear direction in Ashok Ranjan Das. If it is not done for 2 years, spent in court. How that situation has been taken care of? Is there any environment here by any of the orders by this court in any case earlier? See, you cannot find fault with this access because it is in adherence to the guidelines in other. So now, if you need to challenge this, you need to come up with some scope where your case can be considered.
to be very fair, he is arguing that it is not his fault. That's why this 2-year gap could not be taken up like that, your lordship. But possibly some case laws would be there for your lordship to sort of
take care and take the plea. That's it over.
We will have for admission hearing. But whereas as other has is also heard yes, Mr. Nayak, you are also there for public work. And next matter for a claim for compensation. This matter for Senate. And after doing yes.
May I please, your lordship? Lordship, I am appearing on behalf of Mr. A. Kalida for Industry and Commerce Department. Lordship, we need some more time. We haven't received the instruction yet.
Who's for the petitioner? As does J4 C Diwan. Anyone for the petitioner? None appears for the petitioner on call. Whereas the what is it?
N. Kalida.
Whereas the N. Kalida Learned Council representing the Industries and Commerce but has submitted that instructions are in according to this for some time. List of the obtaining of
Here the lordship passed an order. Lordship will find that case 75%. Compassionate appointment.
notice was issued, yes?
Yes. Yeah, well, we have received instruction on written instruction. So lordship placed before more than twice, my lord, it was placed before the SLC and lastly DLC also rejected his case. We want a vacancy.
Yes, lordship can see your lordship's order at page 75. Page 76 is the relevant person. Okay. After hearing the party.
Yes.
After hearing the party, this court is of the opinion that for consideration of appointment on compassionate ground, without at least one such consideration be done on merit of the claim, and as he has been held in a number of such cases, rejection on the ground of lack of vacancy cannot be considered on the merit of the case. In view of the above, The present petitioner is disposed of by directing that the case of petitioner is but considered on merit as and when vacancy arises. It is needless to say that facilitate such consideration. The respondent authority will take resort to the guidelines framed on 1,050 which mandate in case of death of vacancy. Exploring the vacancy in other department is also permissible. But they have to consider only in the office of the chief engineer's office. But you will find that case 79.
Yes.
79, serial number 9. Office of the chief engineer, PW.
Your name is Navajyoti Burman?
Yes, ma'am. In pursuance to the Honorable Guwahati High Court order dated 23/5 in connection with WPC number 12, in connection with the proposal of Sri Narayan Doshi were Navajyoti Burman and Narayan considered, but could not be recommended as 5% quota for compassionate appointment has already exhausted for both Grade 3 and Grade 4. So this is only the office of the chief engineer. They not even consider division. They ought to have
The first paragraph, Lordship, first paragraph, last portion. Honorable Court directed to reconsider the matter of the next SLC. Therefore, the candidature was again placed in the next SLC meeting held on.
Where are you reading?
My lord, our instruction, my lord, first paragraph.
Oh, here. Okay.
First paragraph, last line.
Yes.
The Honorable Court directed to reconsider the matter of next SLC. Therefore, the candidature was again placed in the SLC meeting held on 23rd December 2019. But it was again rejected on the ground that applicant cannot be accommodated within 5% of capacity in any division in Assam. That is applying applying the clause 15 of this notification.
earlier also they have considered only
And
the
thereafter,
division.
next paragraph, petitioner approached the Honorable Court again by petition. Honorable Court directed to furnish the instruction and the department issued a speaking order about its inability to reconsider as per the clause 24B of the Personal P Department, so and so 1/6/2015. The case of the petitioner has been placed before the SLC 2 times and requests no further consideration if the application is pending due to want of vacancies for more than 2 years. Again, the petitioner approached the Honorable Court. The Honorable Court, by its order dated 28.
This exercise was done
Yes, no, my lord,
before June 2015.
yes,
That clause 15
yes.
to consider to have to explore whether you can be accommodated in some other department.
Yes.
That appears to have been done.
But they have not considered in departments, my lord. They have considered earlier, my lord, 23/12/2019 in divisions, any other divisions. And now, my lord, they have considered only in the office of the chief engineer, my lord.
No,
DLC.
in any division in Assam.
Division
In Assam, what
even
was
if,
the-
my lord, they have considered in division, my lord, that is not in, my lord, according to, in consonance with the, my lord, office memorandum. Office memorandum said they have to consider in all departments, my lord, not in division.
Compulsory appointment is a mode of appointment, my lord. It is scheme only. But I immediate, my lord, deed over the, my lord, financial crisis. So they have, according to direction of this Honorable Court, place again and again. If there is no vacancies of 5%, not more than 5% cannot be appointed in the compulsory ground. So there is no vacancy in 5%.
Earlier,
How
lordship-
they will be considered, my lord? And
Lordship-
lastly, last paragraph, Lordship Policy DLC approach Honorable Court by the order dated 21 January 2022 directed that to DLC to consider. Accordingly, it was placed in the DLC in its meeting held on 26/9/2022. DLC did not recommend it to SLC. Since the matter was rejected in the DLC, therefore question of placing the in SLC does not arise.
Lordship may kindly-
It is not a matter of right to, my lord, insist in the court, my lord, again and again. Today is the Lordship, my lord, direct one thing. Again they will do it. Again he will come. It is not a matter of, my lord, right. It is a scheme.
I agree, my lord, but lordship will kindly first see at page 27, my lord. 27 was the DLC recommendation. I was the only candidate, my lord. Page 27. I was recommended, my lord, on 1/3/2016, being the only candidate.
Maybe one can say, but if there is
But they
no
did not
vacancy-
consider it till, my lord, to 2018. In 1906, my lord, SLC, they have placed it, but they have rejected my lord, recommendation without assigning any reason.
It is only recommendation, but there is no indication that there is a
And-
so and so 5% quota.
Thereafter,
No, my lord.
on 23/12, my lord, they have considered
they have rejected my prayer, and that 5% cadre strength in any division, my lord, they have my lord, considered, but that could not accommodate. And that order was challenged before this honorable court. Accordingly, Lordship has passed this order, page 75. So now, my lord, they have considered only in the my lord.
We'll have this for admission hearing. I think your did not file an affidavit. You can give a copy of the instructions to Mr. Kalita.
I
So
can,
that he can also have instructions.
I will file an affidavit, my lord.
You can or you may not, because it's clear. If you want to file affidavit, you can. You want to file affidavit.
Who will file affidavit, my lord?
That side of the direction for a operation now by cross of first of the instruction record would reveal that the exercise was confined to other divisions and not other departments. As per the, on the other hand, that the case of the was on more than one case, and there are it matters that appointment cannot be as a matter of right, and duty constitution part which can pay for, and the same is done there is for the fact. Yes, after that since the but since the state can make based on the date 13 8 5 here they done it. How much time?
2 weeks time, my lord.
2 weeks time. 5 years. This of the
Short time.
P this sort of trick. 3 P is for the public work. Public work. You can take this back. This or
Yes, yes. Oblige.
press cannot be possible. You have to write as a meeting and date. Is there any urgent matters? For interim order is still play.
The next matter, I'll request some time for filing affidavit.
Item number?
Uh,
Who is on the other side?
Item 33-0.
Who is on the other side?
Other side, my lord, it has been brought by order. That's why I did not, my lord, pray in the morning.
We will not record the absence. We'll just say you have
My lord.
on the prayer of prayers of the snake on for the response of 4. Matter is adjourned by 3 weeks to enable filing of affidavit.
Lordship, item number 45, I'm appearing for the petitioner. Here, Your Lordship, interim order is there. That may be extended. Your Lordship. Item 45.
Of time. It's a yes, anything?
Yes, Your Lordship, my item number is 54.
Yes.
Which was about to be heard today. On the last occasion, it was not
Today, there is a meeting we have to write. Now we can fix the date. What was the
The issue is relating to Your Lordship, where the petitioners was straight away being removed from the service without giving any opportunity of being heard, as contemplated under Article 211 of the Constitution.
We'll hear this. You have filed your affidavit. Give us the date, a great date. Can be heard at the efficient stage.
But we haven't received any copy of the affidavit.
Earlier, there was a different set of advocate. I can give.
You give another copy. will give us you tell us the date of your count.
On 6th of this month.
6 is the holiday. 6 we have a holiday. I think
6 is a holiday.
No, 6 is not possible.
6 is not a holiday.
6 is a holiday.
Oh, 6 is a holiday. Then 7.
Case of which year?
22.
22, your lord.
Why extreme urgency? There are many other matters.
But your lordship, the petitioner has been suffering and from 21
All
itself.
petitioner,
He
which
is in-
petitioner is not suffering?
removed
Tell
from
us
the
one
service.
petitioner who is in the court and is not suffering. Nobody comes to the court for fun. There is a 22 matter. We'll hear it, but not on 7th. We'll hear it on. We'll fix on 21st of September, Thursday. It's a hearing date. But come,
21st.
yes, and exchange the affidavit if any.
May I please, Lordship, item number 33, there is a contempt matter, Lordship. I don't have any urgency, but the court's order has been passed 1.5 years back. They have appeared also. They have not filed the affidavit. Lordship,
You're there in the matter 33. Affidavit.
Lordship, we have filed. Actually, it has gone for vetting. We
Then file it within a week. Part 3 Lieutenant Counsel for the petition who submits their affidavit is yet to be filed. Para MSS Ahmed, Lieutenant Counsel for the respondent, however, submits that the affidavit has been prepared and has been sent for vetting and will be filed soon. List after 2 weeks along with the affidavit.
date may be fixed, Lord.
Contempt.
Lord.
Item number 36, Lordship. It's a contempt matter, Lordship, pending since April.
Now, what is the urgency?
Lordship, notice is yet to be issued, Lordship. That is why, Lordship. I have not.
Why earlier it was not notice is not
Lordship, the notice was not issued, Lordship. Actually, on Lordship 35.
you have not appeared earlier.
On 35, Lordship. There is a part compliance of the order, Lordship.
No, but it's part by time. Part by time.
There is a part compliance in the order, Lordship.
Understood, but your when was the order passed? Order was which year?
Order is
30
passed.
December 2021.
No, Lordship. 13 December 2021, Lordship.
And you have filed this contempt when 26 April 2020.
Lordship.
You cannot issue notice like this. You have to convince the court.
Lordship, then Lordship, I may be allowed to file a press release on Lordship on the subsequent development, Lordship. I have been reinstated, Lordship, but
That is up to withdraw this.
Lordship, withdraw blood with liberty to file appropriate certificate.
To each culture that comes for this court by considering this petition on 3/5 has made an observation that the contempt petition appears barred by time. That the Taludar Lieutenant Counsel has, however, that there are subsequent developments which he would like to challenge in the proper manner by and according to days for withdrawing this petition. Para petition according to which liberty has been.
Obliged, Lordship.